like presentation mode.
So how did you find the applicability?
Very wide, almost in all the areas.
Okay. Any other participant? I would like to hear your feedback, participants.
So now cyber law is just not regarding cybercrime. It's much more than that.
Yes, it's much more than cybercrime alone. Correct. Yes. Any more view feedbacks, participants? Any other participant? Pranav, can you open the presentation in the full screen mode? That's what they were asking, I guess.
So I think it's in full screen already.
No, I
Is it?
don't think.
F5,
No, I don't.
just press F5. It will be in presentation mode.
It was in presentation mode before itself.
Okay, now it's not. Pranav, now it's again in the normal mode.
Oh, is it? How?
Now it's not visible at all.
You stop the screen share.
Yeah, now it's right.
Okay.
Correct. So, participants, this is these are the topics that we are planning to discuss today in the afternoon session, where we would be focusing upon the IT Act 2000 and the IT Amended Act 2008. Be taking you through the features of both these, and also tell you what kind of amendments have been made in the 2008 law, and also take you through some different aspects that you will have to be aware of from this legal perspective, so that you actually get some clarity upon the interpretation aspect. So without much delay, I just want to get in directly to that. So like I told you, basically fundamental principle of Information Technology Act is to provide legal recognition and uh, uh, legal sanctity and legal validity to any transaction that is created in the electronic format. So as you're able to see on the screen, this is the main objective of the IT Act: legal recognition for electronic transactions, facilitating electronic filing of documentation, and also making some amendments. So therefore, e-commerce, e-governance are also some aspects that the preamble actually talks about. So fundamentally, we have based our uh, Indian IT Act on UNCITRAL model of e-commerce. So 1996. Not only us, but there are a lot of other countries. For example, Singapore. Then if you look at Malaysia, you look at Mauritius. You look at most of the countries who are part of this UNCITRAL model of UNCITRAL signatories who are part of this UNCITRAL model of discussions. They were adopting all of their cyber laws based on these principles. So almost, if you understand this, you will be able to really understand the national. Let's say the international cyber laws also to a certain extent. because mostly they are based on these principles of UNCITRAL model of commerce. So that's the whole broad ambit. Pranav, next slide. Hmm. So I just wanted to start off with some features of the Information Technology Act 2000. So which specifically mentions about the concept known as electronic records. So we have something known as the electronic records. So what do you mean by an electronic record? Let's say that any document, any information that you create using an electronic device or an equipment becomes an electronic record. So any information or data that you create using an electronic equipment or a device becomes electronic record. So your email is an electronic record. The PDF documents that you create are electronic records. The WhatsApp chats are uh, electronic records. Photographs are electronic records. Videos, and then the documents that you create, whether it's audio, video, image, or text, anything that you create use basically using an electronic equipment can be called as an electronic record. And for that, you are supposed to understand that these electronic records are given legal validity under Section 4 of the IT Act. So that's the whole thing that I want to tell you. So Section 4 of the IT Act clearly says that we are going to recognize electronic records as legal. So therefore, legal validity is given to the electronic records. So therefore, if you go back to the discussion that we had prior to this session, so therefore, I told you about telemedicine consultations. Now, even transactions that are taking place on telemedicine consultation, because ideally the telemedicine guidelines facilitate consultations to take place in three ways. One is through a messaging mode where you interact with the doctor using messages. Second, using an audio mode. Third, using a video mode. All these three are nothing but electronic records under the IT Act. So therefore, they are being given legal validity based on that. So that is the whole purpose of understanding about electronic records. So electronic records are legally recognized under IT Act, specifically under Section 4 of the IT Act and Section 21T. So you'll have to keep in mind that there is Section 2, which always talks about definitions. Any definition that you want to look at, you will have to refer Section 2. So that's the hint that I'm dropping before you. I don't want you to memorize sections, but I just want you to understand how and where to go in case there is a query that you wish to seek. Because all your examination also would be based on open book. So ideally, when we are tomorrow in the next session, when we are taking up the interpretational aspects relating to how we should interpret provisions, you will ideally be required to refer some provisions. So there you would be required to look into the provisions of these sections. That is where I wanted to just give you a hint. Anytime you want to talk about definitions, you can refer to section number 2. So that's the whole objective behind it. Now, like I discussed with you, that IT Act is a masala approach. I just wanted to take you around what all aspects are relating to IT Act. The first one is it has given something relating to electronic records, which are talking about legal recognition to electronic records. Then the second aspect that comes on the discussion is electronic contracts. So we'll discuss about electronic contracts also, but just to tell you, uh, contracts in the electronic format are also given legal validity under IT Act. So that's the second perspective. Electronic records legal recognition, electronic contracts legal recognition, both are some things that IT Act has done. Now, third, it has set up certain authorities. So, who are these authorities? There are some authorities that the IT Act has discussed, and they're created only solely because of the IT Act. For example, there are some authorities that are made responsible. Let's say for the cyber security, who's the nodal agency for maintaining cyber security in the country? We have something called CERTIN, Computer Emergency Response Team. So this is the nodal agency which primarily deals with cyber security, and it is the nodal agency for maintaining cyber security in the country. So it coordinates with the different states. It enforces, the kinds of cyber security measures and mechanisms. It releases white papers to make people aware of the latest cyber security incidents. Reporting. If you say I was discussing in the morning about reporting mechanisms. If you are an intermediary and you suffer with a data breach, you would be required to report the same to CERTIN, which is Computer Emergency Response Team. So this is the nodal agency for cybersecurity. And how is this created? This is created under Section 70B of the Information Technology Act. So likewise, we have certifying authorities, we have controllers. We'll discuss as we go forward, but just to tell you that some authorities also have been created under the IT Act. Now, civil and criminal provisions also have been provided under the IT Act. Now, what is civil? What is criminal? I'll give you a very simplistic understanding on the same. See, you heard of matters where compensation is to be paid, right? Normally, when you say, I will sue somebody, what do you say? I sue you because, let's say that, for example, you suffer a bank related phishing attack. Somebody pushes a phishing page, and then as a result, you suffer some economic loss. So, how will you recover that economic loss? You obviously want money to be paid as compensation. So, anytime there is an involvement of money, compensation and things like that, those matters are considered to be civil in nature. And anytime you have sending someone to jail, imprisonment, penalty, fines, those are criminal in nature. So basically, civil matters and criminal matters, the distinction is one is dealing with compensation, the other is dealing with punishments and penalties. So this is the basic difference that you have to keep in mind. Civil matters and criminal matters. Civil are less offensive in nature, where damages by way of compensation is the mode of remedy that is available to you. And criminal remedy means you can send someone to jail. You can the court will direct them to pay certain penalty and fine. So all that is the court directing it. Here you are using the provision to recover damages. Both are different. So civil and criminal matters are also dealt with under the IT Act. So this is another difference that I wanted to just tell you so that you understand what is civil and what is criminal in nature. Then apart from that, we also have got the authority who's known as the adjudicating authority. Now I was just talking to you about civil matters. Now to handle the civil matters, usually there is an authority created under the IT Act. If you have the authority whom you have to approach in case of a civil related matter, he is the adjudicating officer, is the adjudicating officer, and he's also appointed under the IT Act. We'll discuss more about that, but just to give you an overall perception, I'm just trying to walk you through the salient features. So, e-contracts, electronic records, then coming to the setting up of certain authorities, then civil and criminal matters, then adjudicating authority. Yes, Pranav, let's move to the next. So these are primarily the sections that probably deal with the complete. This is the complete setup of the Information Technology Act 2000. So we do not want to get much into these sections basically, but I just will give you an overall understanding. All these terms which are there, right? Definitions are under section 2. Now everything else we will discuss as we go forward. Please let's go to the next slide, Pranav. Yeah, next slide. Yeah, please keep it here. So in the morning and now we were discussing that any information in the electronic format will be recognized and probably will be provided legal recognition under the ITI. But these things are excluded. So even if these things that you're able to see on the screen are in electronic format, they are not given legal validity. Why? I'll tell you the reason also. Now let's take the example of a power of attorney. Now when you have a power of attorney would have to be put on a stamp paper, ideally, for it to be legally effective. So the difference between an agreement and a contract is, this is what I want to tell you. All agreements enforceable under law alone are called as contracts. So any agreement which is not enforceable under law cannot be called a contract. So this is the fundamental point that you have to keep in mind. So all agreements, only if they are enforceable under law, will be considered as contracts, and any agreement not enforceable under law will not be considered a contract. So now you tell me, can I call an illegal agreement or can I call an illegal contract? I'll only have to call illegal agreements, because any agreement enforceable under law alone can be called as contract. So they cannot be illegal contracts, but they can be illegal agreements. So this is the fundamental difference between an agreement and a contract. So you totally understand the point, right? Only any agreement enforceable under law itself is called a contract. So which is not enforceable under law will not be considered a contract. So classical example of a contract and an agreement is, if I have a piece of agreement with me and I put that on the stamp paper, the first page on the stamp paper, rest all on white paper or on letterhead, that becomes a contract. But if I put the entire contract on my letterhead, that becomes an agreement. So this is the exact difference between an agreement and a contract. Having an agreement printed or executed through the normal white paper or through a letterhead is an agreement. But putting the first page on the stamp paper and then rest pages on the letterhead or white paper becomes a contract. No, I hope you got the clarity now. So are we clear? Please, let me know whether you're clear. So that if you're clear on this area, then it's fine. Otherwise, I just wanted to, I'll clarify your doubts if you have. Are we clear on here? Clear till here? Please tell me whether you are clear or not.
Yes, sir, we are good.
Great. So therefore, now the fundamental point that we have to keep in mind is these documents that you are able to see in the screen, they are not given legal validity in the electronic format. The reason being there is a procedure and process to be adopted. For example, a power of attorney. Power of attorney, you require a stamp paper to be coming into picture, failing which that does not take effect. Same thing happens with will also. If you look at a will, basically, you would have seen in movies or you would have seen, you would have heard dialogues from people saying will has to be returned, that has to be registered. So same way, registration is one another fact. So you have to put it on the stamp paper, you have to register it. Since both these have to have be done physically, electronically, they are not given acceptance. That's one reason. Now coming to trusts, in India, we have a law which governs the trust, which is called the Indian Trusts Act. Any trust deed which is executed by all the trustees will have to be put on a stamp paper. So therefore, it is again a legal requirement that only this trust deed can be put in a stamp paper. It cannot be accepted if it is put on a normal paper. So therefore, that's the reason it is not accepted in the electronic format. Now take for that matter any other document, negotiable instrument other than check. So any other negotiable instrument other than check cannot be again put physically. They require a physical presence, cannot be put electronically. So thereby, that's the reason that we actually try to ensure that this is also not accepted in the electronic format. Now, any document involving sale of immovable property. What do you mean by immovable property? They are properties which cannot be moved. For example, a piece of land, a house, a particular, let's say, piece of property. All these are called immovable properties because they cannot be moved. So when you sell your house, you have to go through the process of registration. You have to go to the registered office. You have to enter into a sale deed. That document will be registered. And it will be put on a stamp paper. The value of the stamp paper will depend upon the the value of the property. All of these are conditions. Since they are legal obligations that have to be done in the physical format, doing that electronically is also not acceptable. So these are the reasons why these documents are not accepted even if they are in electronic format. So these cannot be considered as electronic records under the IT Act, and they will not be given legal validity despite the fact that IT Act gives legal recognition to electronic documents. So get this point right. So I hope you got this understanding. Please be very careful because this is one area that you would have to have complete clarity, because this is one common misconception that people have even from an examination perspective. So I would want you to completely get yourself into this, because please understand what is or what is not included here. Trust deed, will, power of attorney, negotiable instruments other than check, then any documents relating to the sale or conveyance of the immovable property, then any will are not something that are accepted in the electronic format, and they are brought outside the purview. That means they are excluded in the from the radar of the Information Technology Act. So I hope you got an understanding of it. Are we clear till here, or do you have any clarifications? If so, please clarify them. If you're clear, please give me a response so that I will proceed further.
We are good, sir. You can proceed.
Yeah, good.
Thank you so much. Yes, Pranav, please go to the next slide. So this is where I was talking to you about electronic records. So now you also know what is an electronic record. You're very clear on that. Am I correct? Any doubts on electronic records? Are you clear?
We are clear, sir. We are good.
Done. Thank you so much. Please don't mind me asking you 10 times, because I want to ensure that you are absolutely having a basic understanding of what is going on here. So that's the whole point. I don't mind even explaining using 100 illustrations, but I want you to be very clear on the aspects. That's the whole endeavor why I'm trying to go on asking you whether you're clear or not. Now, whenever we talk about computers, now forget what now one golden rule you have to keep in mind. When I'm now talking about cyber law, when I'm trying to now look at the cyber law perspective, I have to keep in mind the legal definitions and not the technical definitions. Please be prepared that when you want to talk about cyber law, when you want to do some frameworks or you want to do some activity under cyber law, whether it's interpretation or whether it's writing a policy, whether preparing a document, you have to keep in mind not the technical definitions but the legal definitions. So forget the technical definitions of a computer. You please understand the legal definitions that we're discussing now about all these items. Once you get the legal definition, the interpretation would have to be made only on the legal definition and not on the technical definition. Because the law is very clear in saying that this is how I am looking at a computer. Anything more than this, I would not consider to be a computer. Despite the fact it may be a computer technically, but in the eyes of law, it will not be considered a computer. So that is a fundamental aspect you have to keep in mind. It's just like the rule book that you have to keep in mind. So if you're driving, how you keep yourself aware about the pros and cons. So the same way, you'll have to be aware about the legal definitions. And whenever you're making anything in terms of IT Act, please interpret them. Please look at them from a legal definition perspective, but not from the technical definition perspective. So that is a small piece of advice I want to give all of you, because even tomorrow when we have the quiz in the next session and when we have your assignments, when we have examination, I would want all of you to please interpret and understand and give the reasoning based upon this technical definitions. I mean, not technical definitions, but legal definitions. But please be aware of that point. So that is where I wanted to just caution you, because this is one point that a lot of IT professionals miss out. I do not want you to miss out the same. So therefore, I'm giving you a disclaimer in the beginning itself. So this is how you are supposed to look at a definition, basically. Whatever be the definition terms that we are discussing now. So the IT Act has now come up with a definition known as what known as something what can be termed as a computer. Now forget everything that you're able to see on the screen. I will just tell you three aspects as a key. If you want to call any device a computer under IT Act, there needs to be three elements that you have to look into. First element is the memory. Second element is the capacity to follow and understand instructions. So arithmetic and logical unit. Third, computational capability. If these three can be present in any device, that device can be called a computer. So memory, arithmetic and logical unit, and the computational capability. If these three are available in any device, that device can be called a computer. So this is the basic understanding that I would want you to keep in mind. So whenever we are using the term computer in the IT Act, it means this is the interpretation you should look at, not the technical definition of what's a computer or not your understanding on what's a computer. You should primarily look at the legal definition which classifies these three elements. So I will ask you one question. I would like to hear your feedback. Now you tell me. Is a automatic washing machine a computer based on this definition? I would want to hear from you, your views. Can I call an automatic washing machine a computer under this definition? If yes, why? If
Yes.
no, why?
It is satisfying all the clauses.
Correct.
If
It is
it has
satisfying all the
the,
clauses.
yeah,
Okay, absolutely. I totally agree with you. What about other participants? So, what is your viewpoint? Do you agree that it is a computer, or do you dispute that it's not a computer?
Yeah, I agree. It's
Agree.
computer.
Okay, everybody agrees. I will ask you one more question. Now, is an automatic teller machine, an ATM, a computer?
Yep.
yes,
Yes.
Okay, okay. So now you are able to understand and you're able to interpret what is a computer, because this is the way that you have to look into. So when you talk about the legal interpretation, So this is where I said we are going out of the box, because these kind of interpretations are even not today taught in law schools. So my endeavor, like I told you, is to give you a hands-on understanding from a practical perspective how you should look at the legal provisions, so that apart from just imparting a theoretical or academic knowledge, I also wanted to instill the practicality of how interpretation could be looked at, so that it helps even you when it comes to policy making, when it comes to understanding the requirements, when it comes to putting things in respect of compliances, you'll be able to practically interpret the same. So that is the whole endeavor of me putting these questions and me taking this approach. So I hope this gives you some practical overview as well. So that's the whole point of uh, the kind of explanation that I have now chosen to go ahead. So now you understood what's a computer. So any clarity that you wish to seek, anything that you want to ask me here, can please feel free to ask me. Otherwise, let's go more to the next slide. Pranav, can we
Can
move to
you,
the next slide?
hi Sushant, can you give
Please,
example
please.
of what is not computer in electronics? Devices
For
for
example, okay. For example, let's say a semi-automatic washing machine
yeah, okay.
may not be considered as a computer full-fledged. Now, let's take an example of a normal refrigerator. Normal refrigerator cannot be called a computer, but you have smart refrigerators that are there, which have the capacity to connect to Wi-Fi. They give you the temperature. They allow you to do various kinds of activities. That is a classical example of computer. And what is not a computer? A normal fridge is something that you can call it as a not a computer, non-computer. Likewise, let's take the example of the normal this one that you have, normal television. The normal television may not have memory altogether, but now today you have smart televisions. Smart television definitely can be considered a computer, basically, because they have the internal memories also. Some televisions come with memory also. You can record, you can store, you can do a lot of other activities. Likewise, just go back and check some examples, the normal things that are available with you. For example, a normal
Most of
say,
the
let's say,
IoT devices we can say.
sorry, yeah, non rest of the IT devices, you can say anything that
Most of the
cannot,
IoT devices, sir.
sorry,
IoT devices.
most of the IoT devices can be called a computer. Rather, I would say every IoT device can be a computer. So are you clear on it?
Yeah, yeah.
So likewise, see today what happens is that, see, I can also call. I do not know whether you are aware of it, but I just want to tell you when it comes to IoT, you have even today IoT based clothing. I don't know whether you're aware or not. See, a normal shirt and a smart shirt. Arrow company, Arrow ARROW. I don't know whether you are aware of this brand called Arrow. Arrow actually had come up with a smart shirt which was able to link. They had a small sensor kind of a thing which was able to get linked to your mobile phone. There was an application wherein you were able to get some details. For example, let's say that you are wanting to exchange your information with somebody. You could do that using your smart shirt. They were available for sale even on Amazon. But now I don't think they are anywhere any longer available. But they were available at one point of time. So classical example, there's that shirt could also be termed a computer because it had the capacity to follow your instructions. There was a storage also enabled there. So a lot of activities were possible with that shirt. So that's unfortunately, I did not buy that shirt at that point, keeping in with the security angle. But yes, I can maybe in the next session I can try to get you the photographs of that, how it operates and things like that. So that's a classical example of a computer, and a normal shirt is an example of non-computer. So if you draw a comparative degree between both.
Okay, got it. Yeah.
So anything basically, see even your smart watches, your wearables, medical Fitbits, anything that you're trying to make use of today, the smart glasses that you have,
We
all
can take
this.
example of automotive also. Previously, automotive, most of the things were electric.
Correct. Today,
Now
you see,
it's
most of them are electronic. See,
yes.
today cars have got the capacity to do lots of other activities. You can connect your. There's an Apple CarPlay. There's Android Auto. A lot of things are given. as part of the infotainment system. Those infotainment system can also be a computer under the IT Act.
Yes.
So you will have to this. In fact, you raised a good point, because I think in the last batch this was one of the questions that we put up actually. The smart infotainment system of a car, is it a computer?
Obviously, it is a computer.
So it is a computer. And because there was an interesting case, I do not know whether you get access to the old batches papers, but I would recommend, if you get access, please do a check on that, so that you will have an understanding of how the questions are framed, in the interest of your perspective, if you are really interested in getting some understanding on it. Because I would love to be making it. I requested, in fact, Reva to make this a open book system, because they told me open book cannot be taken. But I requested them that the slides, whatever we are presenting today, and if you're taking notes, then you can do that. Those can be used as the material for reference. Because they told me you can't carry printed material. I said fine, they will not carry printed material, but this is at least permit them to do that. So they've accepted my request last time. So I'm hoping that you try to make notes, or you try to do some write up or something on this, so that you can use that as a material for your examination also tomorrow.
Sure.
So I hope you're able to understand the concept of a computer. So now I'm moving a little bit more further. This was introduced in IT Act 2000, but 2008 we went on to even add up a new term, which is known as a communication device. Every mobile phone is also a computer, ideally, but we went on to broaden the domain of communication. So we went on to add a term known as a communication device. So what do you mean by communication device? Any device which has the capacity to do some activities. What are the some activities? If a device is basically able to store, receive, transmit audio, video, image, or text, that becomes communication device. So any device which is capable of storing, receiving, transmitting audio, video, image, or text is called a communication device. So even an iPad which is not having calling facility is considered to be a communication device. So a personal digital assistant can also be considered a communication device. So likewise, we try to broaden this domain by including communication devices also. So I would say the IT Act, this Indian Cyber Law, is also the first step towards bringing Indian mobile law also into the domain. Because anything that are taking place through iPads, through mobile phones, through tablets, are also now covered under the radar of IT Act. So that is why I said in the morning that look at the wideness and scope of applicability. So that's the reason I told you it's one of the what do you say, it's most significant laws being passed by India post independence, because this is a unique piece of law, and it is so vast that any activity that you do digitally is covered under the ambit of this particular law. So that's the whole point that I want to derive you to. So I hope you got an understanding on the communication device as well. Yes.
Just one
No,
question.
please go ahead.
Sushanth, so these communication devices will be first computer and then communication devices,
But they
right?
can be both. They can be both. Sometimes they may only be a
Used for
communication device. So it can be both. There's no harm in interpreting both. Because
Okay,
a
but
mobile phone
if
can be a
memory is
computer and a
not
mobile.
there, then it will be, when it just used for transmission, then it will be a
It will be
communication
a
device, but
communication
not
device.
computer device.
Correct. Exactly.
Uh-huh. Uh,
So that's the reason we have come up with the two distinctive definitions, and we
uh,
have broadened the horizon.
uh,
So that's the whole point, that why the 2008 law had actually made this amendment. Because in fact, I would say that the 2008 amendment introduced a wonderful component. What is that wonderful component? It has made the entire law technology neutral. So I tell you how. I do not know if whether you are aware, but in the interest of the people, I just want to just tell you, because you're not from the legal background. You know how a bill is made into an act, right? The bill will be introduced in the parliament, then there'll be voting, present and voting. If two-third majority is there, then that becomes an act. All these cumbersome process is required for any bill to become an act. But the IT Act 2008, when it was amended, it simplified the entire process. It said you don't have to go through the cumbersome process of introducing a bill in case you want to make amendments. It has come up with a concept known as a second schedule. That second schedule, if you introduce the revised or the new provisions, you can introduce them in the official gazette, and the gazette notification is enough. If you include them in the second schedule, and that second schedule is published in the official gazette by the government, that takes effect immediately from the date of publication. So you have completely a freedom to do what you want without going through the cumbersome process of introducing it in the parliament, getting the present vote, the majority of voting and all that. That entire cumbersome process has been withheld down, and a simple concept of introducing it into the second schedule and getting into effect has been introduced. And you'll be surprised, despite the fact that it's now 14 long years, not a single provision is there in the second schedule. If you go to IT Act 2008, you open the second schedule, you will find that it's empty. There's not a single provision being introduced. Despite the fact that the law has given you an advantage of introducing new provisions relating to new technologies, we still have not made that despite the 14 long years. So that is the unfortunate and sad reality that we have to accept. So this is where I said the entire act has been technology neutral, because technology never stops at a particular point. So if you want to make the law in sync with the technology, and if you think that there are new provisions required for the same, you can do so immediately by putting them in the second schedule and publishing them in the official gazette, and it takes effect from the day you publish it in the official gazette. So that's the entire reason I told you that the law has been made technology neutral by the amendment in 2008. So some good things have happened in 2008, some bad things have happened in 2008. But like I said, everything has pros and cons. But this unfortunately is not being utilized by us, by the government anywhere in these 14 years. Otherwise, they could have come up with this beautiful provision. But unfortunately, they have not done that. That's the sad reality. So that's one of the key features of 2008, technology neutral. So now you got an understanding about three aspects. One is the concept of a computer, the other is a communication device, and the third being technology neutral. Now let's go a bit more further. Now in 2008, like I told you in the earlier session, we came up with a small definition for cybersecurity. So we defined it and said cybersecurity does not just mean the data or the information security. It also means the physical security of the device. That is, to put it in very simple terms, I'm not going through the exercise of making you run through the entire definition, because that makes the session very cumbersome, and you do not need to get into that completely because you're not practicing in the code of law. So I just wanted to give you a synopsis, so I'm making it very crisp and very what do you say, light, so that you can understand the essence of it. So when you look at the definition, this definition is very simple. It says cybersecurity does not just mean protecting the information or data in a particular device, but it also means physical security of that particular device. That's the main broad aspect that you will have to keep in mind. So that's the whole agenda of this particular definition. Of course, this is just on a way to interpret what is cybersecurity. That's it. Yeah, please, let's go to the next. So this is where I said, yeah, it covers both the physical as well as the information security. Yeah, next. So this is the authority I was just talking to you about a while ago, where I told you about CERTIN, Computer Emergency Response Team of India. So therefore, this is the nodal agency, like I told you, with regard to cybersecurity. So a lot of times you will get certain advisories. If you go to CERTIN's website, and you can go ahead and see the advisories, the white papers, the downloads that they provide. So that's also something that you can do as a company, just to be aware of the latest happenings. So that's something that I just wanted to discuss. Yes, can we go to the next? So now 2000, we had a lot of difficult agendas. What were the difficult agendas? We said, should you wish to seek damages by way of compensation for any cyber offense? I would not say offense, I would say cyber contravention. Because like I told you, offense is criminal in nature, contravention is civil in nature. I also have a, difference table, but just to tell you that this is the damages part. Now, the IT Act said, should you wish to seek any damages for any under any provisions of the IT Act, you can claim damages only up to a maximum of 1 crore. What is this 1 crore? If I suffer 2 crores, why should I only be able to get 1 crore? That was the question that most of the people asked. And the cap was removed by 2008. 2008 said unlimited damages. If you suffer 100 crores, you can get 100 crores as damages, provided you actually prove that there's a damage of 100 crores being suffered by you. So that's the good part of the story. The 2008 law did. 2008 law also said data privacy. Earlier, 2000 law said, yes, we are looking at privacy. We are looking at some compliance obligations, but those compliance obligations were not given complete clarity under the 2000 law. 2008, we went on to say that, yes, this is what we mean by data privacy. And we tried to give some definition of what's an intermediary. And then we tried to talk about what kind of reasonable security practices and procedures would have to be exercised by companies so as to ensure they're compliant. We also came up with certain definitions. For example, the definition of communication device. Then the question of what's a cyber cafe. Till then, we do not have an understanding of a cyber cafe because we just were trying to interpret it in some lay language that we could look at. But given the fact that cyber cafes were the main source of cyber crimes during those days, we went on to define what is a cyber cafe, and cyber cafe guidelines also were brought in as part of the amendment. So what a cyber cafe should be doing as part of this obligations. Of course, broadly, if you see, 99% of the cyber cafes do not have this. Maybe 1% of cyber cafes are doing that. But today, I don't think the cyber cafes exist also today. Because with everybody carrying a smartphone, I don't find necessity for any cyber cafe to get operational. So this, unless you're in a place where you do not have a proper network or something like that. So that's something that 2008 law had did. And it made the entire act as technology neutral, like I just discussed with you. Yes, can we go to the next slide? So we also came up with a nodal agency of certain in the amendment. Earlier, we did not have a nodal agency. When we additionally defined certain cyber crimes and we prescribed the punishments for the same. And earlier, if a cyber crime is to be investigated, there was a particular level of police. For example, any officer below the ranking of Deputy Superintendent of Police, whom we call DYSP, were not supposed to investigate cyber-related crimes or offences. That became a problem because the number of DYSPs, people above the cadre was a challenging factor. Then 2008 reduced that and said any person in the police who's an inspector can be able to register a case and could be able to do investigation of cyber offences. That kind of provided more manpower. So thereby, that was my main intention why they reduced the level from a DYSP to a normal inspector. Yes. Next slide. And now we have a clear-cut matter that I would want to tell you. Now, adjudicating officer. Now, adjudicating officer is the officer who would be one of the main adjudicating officer would be the one of the authorities whom you have to approach in case of civil matters. In case of civil matters. So we have both civil and criminal matters in the IT Act. So criminal matters, you can go to a criminal court, you can go to the High Court, you can go to the Supreme Court. But civil matters, up to 5 crore rupees. Because in civil, like I said, civil, we call that as jurisdiction. So what do you mean by jurisdiction? Jurisdiction means the power of the court to hear or handle or adjudicate that particular matter. So that's why you see a lot of times people say this court does not have the jurisdiction. What do you mean by jurisdiction? The power to adjudicate or settle that particular issue. So that's why you see a lot of times, even on movie tickets, if you see, they write these statements. All disputes subject to jurisdiction of Bangalore only. So that means what? If you have any issue, you cannot go file it in Chennai. You cannot file it in Hyderabad because the jurisdiction is based on the place. The jurisdiction means the power of the court to handle, to settle, to entertain, or to take up the particular matter. That's called jurisdiction. And jurisdiction is usually based on three ways. One is based on the territory. It's called territorial jurisdiction. Second, it's based on the subject. What kind of a subject is it? Is it a matrimonial dispute? Is it a corporate issue? Is it something to do with personal law where you have religion and things like that? Or is it to do with banking? So depending on the subject matter, jurisdiction is there. That's the second form of jurisdiction. Third form of jurisdiction is pecuniary, which means money. So three forms of jurisdiction again. Jurisdiction is classified in three forms. One is territory based on the location. Second, based on money, pecuniary. Third, based on the subject, which is subject matter. So these are the three ways how jurisdiction can be invoked. So jurisdiction is the power of the court to entertain or to hear that particular matter or adjudicate that particular matter in simple sense. So that is where you have all these people writing. Even on bus tickets, air tickets, you see a lot of websites also write. If you look at the terms and conditions of some websites, you see that they mention a jurisdiction clause. They say all disputes subject to the jurisdiction of so and so. Why? Because they're taking the advantage of territorial jurisdiction, because wherever they're located, they want that jurisdiction to be put in. Even in companies, you see, you open your offer letters, you open your appointment letters, they say the jurisdiction will be such and such a place. Why? Because that is the place where they're located. So that is the reason they invoke territorial jurisdiction. So I hope you got some clarity. Are you clear on the jurisdiction aspect? So I'm hoping, please give me some response so that I'm aware that you're following it up. Are you aware about what is jurisdiction and the forms of jurisdiction? Any clarifications? Anything that you wish to clarify? Please, I'm free to discuss. No problem. If you're clear, please give me a response so that we go further on it.
We are clear about location jurisdiction, but other than that, we might need to research on that.
Two more matters. One is subject matter. Depends on the subject. What kind of a matter is it? Is it a civil matter? Is it something to do with property? Because in civil also you have different matters. Is it based on family? Is it based on property? Is it based on a corporate? There are so many subjects there. So depending on the subject also, jurisdiction will be there. For example, if it's a tax matter, then only tax related authorities will have the power. So you cannot file that with anybody else. For example, you have the adjudicating officers for particular tax related matter, GST. You can't file that with any other authority. You can't file it in with the adjudicating officer under IT Act, because GST has a separate domain, because it's a separate subject on its own. So that is what we mean by subject matter. Are you clear on it now?
Yes, I'm good.
Okay. Now the third being pecuniary, which is talking about money. For example, under IT Act, if I want to get a compensation from some individual or from some company, because the company has done some violation of any of the provisions of IT Act. Now, what will I do? I want to get compensation, so that's a civil matter. If my compensation is below 5 crore rupees, I can go to the adjudicating officer. If my compensation claim is more than 5 crores, then I have to go to a normal civil court. The adjudicating officer cannot be the right party to handle disputes of, I don't even say disputes, damages for compensations below 5 crores he can handle. Above 5 crores he cannot have the power. So it is just like the organization chart. In your team you may be having different levels. You have different levels of employees. So just like you have a reporting manager, some people report to one set of employees report to one set of managers. Then the managers report to some other senior managers. Senior managers, they report to vice presidents. Vice presidents, they appoint to they report to the board. Then there is a board of directors again. Then if there is a CEO, then the CEO is also answerable to the board. Just like you have the local, hierarchy. In the same way, we have a hierarchy here also. Below 5 crores, you have to go to an adjudicating officer. Above 5 crores, you have to go to a civil court. So that is the reason we call that as pecuniary jurisdiction. So which is based on the amount of damages. That's why I say money. Pecuniary means money. Are you clear on this now? Subject matter, territorial, and pecuniary. Territory is the territorial physical boundaries. Then it's a place. Pecuniary is money, and subject matter is the subject. Are you clear now?
Yes, sir. Just a quick question. Does
Please, go ahead.
does it have any framework which every company has to abide by?
No, there is no framework as such. Framework is not respect to this. Framework is respect to policies. You have a framework definitely that we'll be discussing in the fourth session. But currently for reporting, you have to report it to certain. But should you wish to file a case, you have to be aware of where the case has to be filed, basically. So that's the reason I'm just trying to tell you about the adjudicating officer, basically. Because
Sure.
if you want to get compensation, let's say, should you wish to get compensation on behalf of your company, so where is the right place that you want to approach? Personally also, let's say you lost out some money as a result of some banking transaction, where will you go ahead and fight? Because outside the company also it's important, because we are all living even in the digital environment. Apart from professional activities, we are also doing a lot of activities digitally online. We are doing electronic transfers. We are transferring money through different forms. Maybe you're doing a NEFT transaction, IMPS. You're doing a Google Pay related transaction, Phone Pay, whatever. You're using your e-wallet. You're using whatever it be it. Suppose you lost out the money because of some issue. You should have an understanding where do you file a case tomorrow? Because if you go to a lawyer, you must also have an understanding that if your compensation is below 5 crores, the person you'll have to go and approach would be the adjudicating officer under IT Act, especially if there is something that has happened without your consent and there's something that you wish to seek because of that. That's an important point that you have to keep in mind. So that is where I said below 5 crores, adjudicating officer. Above 5 crores, normal civil court. Even if you're not happy with the civil court, you can go to a high court also and file a case. Nothing barring you from not doing that. But the hierarchy goes like that. For criminal matters, there's a clear hierarchy. You go to the criminal court, then you go to the high court, you go to the Supreme Court. There's a clear hierarchy. But for civil, there is a small setup here being given under the IT Act. So IT Act says, should you wish to get your compensation below 5 crores, you can go to an adjudicating officer. Now, who's an adjudicating officer? The IT secretary of the state, the information technology secretary of a state is considered to be an adjudicating officer under IT Act. So his appointment is also done under the IT Act, specifically under Section 46 of the IT Act. But sad reality is, if you go and open the states' websites, the government websites, and see how many states have really appointed adjudicating officers, you will be disappointed. The reason being, I think there are just handful, not even handful, I will say, I think more about 3 or 4 states, maybe maximum 5 states have really officially appointed adjudicating officers. Beyond that, we do not find any adjudicating officers details anywhere in the government websites. That's the fact, the sad reality that we have to accept. So this is where in the morning when you discussed and told me awareness, yes, awareness is also required at the governmental level, which is missing. See, I'm telling off the record that in Hyderabad, I happened to meet the IT secretary because I was part of the IT security, IT policy launch. And then I happened to discuss with him. And when we were sitting one on one, I told him, sir, has there been any matter moved before you because you are the adjudicating officer? He looked at me and said, do I really have that authority? I'm not aware of it. It's a hard reality that we have to accept. Barring few states, the unfortunate aspect is most of the adjudicating officers do not have an understanding that they have the power. Forget they're hearing you, but they do not even know that they have that power. That is the sad reality that we are in today. That's the reason why even the court settlements in this domain have not even touched 3 digit. The cybercrime conviction in India, it's now been 21 years and 22 years rather. So we have not even touched 3 digit. That means not even 100. Why? Because awareness is not there. But unfortunately, that's the hard fact we have to admit. So when you do not have an authority to whom you want to represent your case, then where will you go ahead and then get damages, or where will you be able to get successful orders? That's the big drawback. Maharashtra, Karnataka, some of them are here and there, but the other people are not even active. No details have been specified whatsoever. So that's a bad news that we have to look into. And the other sad news is that we have another authority constituted. Now you will say, I go to the adjudicating officer. I am not happy with the judgment given by him. What do? I want to file an appeal against the judgment. Where do I go? We constituted a separate court. We call that as a Cyber Regulatory Appellate Tribunal, CRAT, CRAT, which is called Cyber Regulatory Appellate Tribunal. That means look at the word cyber regulatory. That means it's created based on a regulation, which is the IT Act, and it is only having powers with respect to cyber matters. A, appellate. That means you can't directly approach that. You can only go on an appeal against the order of the adjudicating officer. So it cannot be directly approached. Tribunal. It's not. It's something like a court. So therefore, we have constituted a separate court, which is called the CRAT, and we said the CRAT will have the power to dispose or settle the matters, adjudicate matters which are heard by the IT secretary, and people who are appealing, you can go and file your appeal with the Cyber Appellate Regulatory Tribunal. But unfortunately, today there is no existence of this court. We have merged it based on the Finance Bill 2017. We have merged it with the TDSAT, which is the Telecom Dispute Settlement Authority Tribunal. That's the sad reality. So we are on one hand facing a problem that we don't have the adjudicating officers. On the other hand, even if you have an adjudicating officer, and if the adjudicating officer has you not given any proper direction, and you want to appeal against the same, there's no authority separately constituted for the cyber offenses. I won't say offenses, cyber contraventions. To here, there's no authority. You have to directly go to the High Court. That is a hard reality. We do not have a dedicated cyber-related tribunal that's there functioning. That's no longer there. It's now moved to TDSAT, merged with TDSAT. So that's the hard reality that we have to keep in mind. So that's the hierarchy of how the cyber contraventions, that is, if you want to claim compensation claims because of some activity happening online, if you want to claim damages, these are the authorities. First, you go to the adjudicating officer in case it is below 5 crores. If in case you are wanting to appeal against the order given by the adjudicating officer, you go to the TDSAT, which is the Telecom Dispute Authority. Then, if you're still not satisfied, you want to further raise and make an appeal, you can make that before the High Court, and again you can go to the Apex Court. So this is the hierarchy as far as civil matters below 5 crores are concerned. Above 5 crores, there is no problem. You can directly go to the civil court, city civil court. Then you can go further to the High Court. You can go to the Supreme Court, and there ends the matter. But the challenge is that we do not, unfortunately, have this active litigation in this domain. So that is the hard reality that we have to keep in mind. And the adjudicating officer's qualification, appointment, what are the things required, what all powers he has got, all of them have been clearly specified in the IT Act. So whatever powers are there for a civil court, the same powers have been given to an adjudicating officer, because he's also equivalent to a civil court up to 5 crore rupees. So that's the point that I just wanted to communicate with you. So did you get an idea now about the adjudicating mechanism and how it operates in the country? So
Yes,
please,
sir.
Yeah. Yes, sir.
great. Any clarifications? Anything that you wish to discuss? And usually they are IAS guys, because IT secretaries will be usually IAS officers. So the qualifications are, you must have you must have worked as a director for a government enterprise for a period of 9 years. You must also be part of the legal department for a period of 3 years. Blah blah blah. A lot of things have been put up, and unfortunately, the sad reality is awareness is missing. That's the whole point. So now let's go a bit more further onto the other aspects of electronic signatures. Now, IT Act said, okay, now I spoke to you about electronic records. Fine. Now, the second question that you will ask me is, just like I sign on a physical document, how do I authenticate my electronic record? Very simple. How can you authenticate an electronic record? You can authenticate it by affixing your digital signature. So digital signatures are something that are equivalent to the physical signatures in the physical world. Just like if you want to sign, if you want to execute an agreement, you make use of signatures, right? In the physical form, you sign on the contracts or you sign on the agreements. Similar way, you actually try to affix your digital signatures. So once you affix your digital signatures, the document, the electronic record gets better legal enforcement. So the IT Act says, should you wish to authenticate your electronic record, we will accept it, no doubt. But if you want to further authenticate it, you can do so by fixing your digital signature. But unfortunately, when it came to digital signatures, they found that there's some kind of a loophole that could be used. So then they introduced the concept known as electronic signature. So the IT Act 2000 said, should you wish to authenticate, you can do so by fixing your digital signature. But the 2008 law said, should you wish to authenticate, you can do so by fixing a electronic signature. Now, what's the difference between an electronic and a digital signature? And what's the current position? Digital signatures are something that you can purchase from a certifying authority. And who's the certifying authority? An authority who is appointed under IT Act for the purpose of issuing digital signatures. So you must have seen there are lots of there are 7 certifying authorities in India, of which TCS, eMudra, all of these are also some certifying authorities. And these certifying authorities issue digital signatures. Apart from just giving you a digital signature, they issue a certificate. That certificate is called digital signature certificate. So this was the present position under IT Act 2000. But 2008, we went ahead and we included electronic signature. What do you mean by an electronic signature? How is it different from a digital signature? Digital signature usually comes in a USB token. You have a USB drive, you got a private key, public key, all of these are there. We'll discuss about that also. But just to tell you that that is a classical example of a digital signature. Electronic signature, your fingerprint, that is biometric, retina scanning, then your facial recognition, then your Aadhaar based OTP system. All these are classical examples of electronic signature. So should you wish to exercise your option given under the IT amended act of electronic signature, you can also do that. So the present position is, since 2000 and 2008 both are there, we can right now use either digital signatures or electronic signatures. So both are currently accepted in the present as a present given the present position of law. So should you wish to authenticate. So electronic signatures and digital signatures, any one of them could be used currently for the purpose of authenticating your electronic records or transactions. This is as far as authentication is concerned. Are we clear on this? Any doubts, any clarifications? Or if not, if you're clear, please give me a response so that I have an idea.
No, sir, you can move on.
Please, thank you so much. Pranav, please, let's move to the next slide. This is the corporate responsibility now. Now, there are some provisions that we have with respect to corporates also. These are called the corporate provisions under the IT Act. So what do you mean by the corporate provisions? So I was just in the morning discussing with you the concept of an intermediary. So intermediary means any body corporate also. So if should you wish to emphasize any corporate responsibility upon a company, well, how do you do that? You'll have to refer to section 43A, capital A. Capital and small hold a lot of difference in the eyes of law. So be very careful on selecting your options, because A, capital, A, small will change the scenario altogether. So that's something that I want to keep you aware of. So this is the corporate provision of the IT Act, which talks about putting in certain kinds of compliance obligations upon an intermediary who is also a body corporate. If you're a body corporate, if you do not exercise reasonable security measures, if you do not have due diligence, then this is the section that you would be charged with, section 43A. In addition with that, we also have a corporate provision of section 85. So these two sections will be dealt in detail in the 4th session, where we talk about the data protection legal regime. But just to give you an understanding that corporate provisions are also there in the IT Act, which are applicable to companies. Yes. Can we go to the next slide, Pranav? And 43, yeah, this is the slide that please put it here. So 43 capital A is applicable for companies. 43 small a is also applicable for individuals. So one is something which is totally relating to any contravention. Contravention and offense. What is the difference between this? Contravention means a simple violation, and offense means a serious violation. So classical example that I would like to talk to you about contraventions and offenses are, just take the example of a vehicle. Let's say let's take the example of vehicles. Now, if you bypass a traffic signal, that's a simple violation. But if you go and collide with a car and as a result you hit a person, he suffers some kind of an injury, that becomes an offense. But the mere both are not both are breach of the rules itself, but you understand the degree. One is civil in nature, one is criminal in nature. That's why when you immediately bypass a signal, traffic signal, or you bypass the speed limit in Bangalore, I'm sure you must all be aware of the 80-kilometer speed limit that you have, right? When you're traveling to the airport, that's a simple violation basically. So that's a contravention. So that's why you'll be fined basically, because it's civil in nature. But should you go ahead and collide with somebody causing an injury to that particular person, that becomes an offense. And you have the case will be registered against you for rash and negligent driving, where you will be actually trying to face some penalties, and sometimes a case will be filed in the police station and things like that, because it is an offense, criminal in nature. So do you now get the distinction between contravention and offense? Are you clear? One is civil, one is criminal. One is sending someone to jail, the other is getting money. One is talking about the simple violation, the other one is serious violation. So do you now get the complete clarity between offense and contravention? Are you clear on it? Please give me a feedback so that we can go forward.
Yeah, we are good, sir.
Great, excellent. So this is what I was just talking to you about. I'm not getting into that. So cyber contravention and cyber offenses. Yes, I have already covered this. Yes. Now coming to these concepts, we already discussed about communication device, and I'll also like to talk to you about a computer network primarily. Okay, before going till there, I just want to take you through whatever we discussed so far. We discussed about what's a computer. We discussed about what's a communication device. We discussed about electronic records. We discussed about authentication of electronic records. We discussed about the different aspects which are outside or excluded in the purview of the Information Technology Act. And we also discussed about the investigation and the salient features of IT Act 2000 and 2008. How are they different? So broadly speaking, these were some things that we've discussed. So I hope you got a clarity on this. Any clarifications do you have with respect to any of these? Here also just want to take one part, that's it. Computer network. So computer network also includes any Wi-Fi connectivity. So therefore please understand that Wi-Fi connectivity is also now considered as a computer network under the IT Act. So are you clear on this? Can we proceed next? Do you have any doubts, clarifications?
We are good, sir. But just a query.
Please go ahead.
Do we have any case studies of just only case studies from India? So it explains a better way.
Yes, we do have. In next session, when we're talking about cyber crimes, definitely we are taking you through the case studies as well.
Okay, sure, sir, sure.
Because now getting case studies won't be of help, because see, we have not discussed any offenses or crimes in this session today. So therefore, getting them would first be a tedious exercise of first running you through them, and then unless you understand what are they actually, you'll not be able to relate to the case, right? So that's the whole perspective why I've not got anything on the picture. Today, just to give you a broad understanding on the domains, that's the main focus that we have today, and also take you through some of these provisions. Detailed walkthrough on the crimes we'll be doing it in the next session, so that we'll have more better understanding. Yes. Can we move to the next slide? Yes. Now, this is also something to do with contracts. I have a very interesting case study of contracts also here. So we'll be discussing about that also. But just to tell you that we have two provisions that you have to keep in mind. One is the provisions relating to e-contracts, and the other one relating to e-audit. E-audit means what? Whatever financial audits that you're doing. For example, let's say that should you wish to do some financial audits for organizations, the same thing will be even applicable electronically also for doing an audit. And same thing happens even with the storage of documents. For example, income tax returns, they say for 7 years you have to maintain ITR. Likewise, if you're storing your ITR in the electronic format, you also will be required to use put them for 7 years. So same rules and regulations apply. So I'm not getting much into that. But the fact that I want to emphasize now with you is electronic contracts. So let's discuss more on the electronic contracts, because this is something that even as an organization you will be looking at when you're drafting out policies or agreements. Now, fundamentally, there is a section named Section 10A, which provides legal validity and recognition to electronic contracts. Now, what does it say? It does not directly say that legal recognition, we recognize and give legal validity to electronic transactions. That's not the wording or the letter and spirit of the law. The law has a different wording. It says no contract should be denied legal enforceability solely because it is in electronic format. So it says no contract should be denied legal enforceability solely because it is in electronic format. So therefore, we are trying to say that this is the section, the legal interpretation is legal recognition is provided to electronic contracts. That's how we are able to draw a inference and say that this is a section that we have to use for interpreting validity and legal recognition to electronic contracts. So that's the way we are looking at the essence of the provision, not the way how it's put in the general sense. Because no contract should be denied validity solely because it is in electronic format means that just because a contract is in electronic format does not mean that I deny giving enforceability to it. But it is again subject to. What is a subject to? Two subjects are there. Two terms and conditions. In ads also you might see, right? So many times they say terms and conditions apply. So what are the terms and conditions here? Two terms and conditions. One, the other things what are excluded, the will, the power of attorney, all these are not accepted, even if they're in an electronic format. Second, if you breach the essentials of a valid contract under the contract law, that is also not accepted. Now, every particular topic that we discuss has a relevance to a law. What is the law? Contract law. Because we are talking about contracts, it's a contract law. It is going to be the mother legislation for this. If you talk about evidence law will be the mother foundation for it. So therefore, you have to understand the correlation between the IT Act and the contract law. So should you say that this is an electronic contract, you have to also satisfy the legal requirements of it in the context of Contract Act. What does the Contract Act says? Contract Act says that should your contract be legally enforceable, there are these conditions. Number one, there should be certainty. You cannot have something which is uncertain. Number two, you should have a sound mind. Contract with minors or contract with people who are not having a sound mind do not legally be a party to contract. Third, there must be a legal relationship between the parties. That means legal relationship is both the parties should have a proper legal relationship. Fourth, there should not be any kind of a subject matter which is prohibited or which is against a particular law. So you cannot have an agreement for download of pirated movies. That cannot be a valid one. Though you put it on the stamp paper, that will be denied legal enforceability. So this is a very important aspect that you have to look into. And the last one is age. You should not be below the legal age, which is 18 years. That's why when you sign up with minors, we say yes, parental consent is required. So that's the whole point that we have to look into. So this is the basic foundation principle of your contract. So for a contract, you have 5 elements again. Offer has to be made. An offer has to be accepted. Then the acceptance has to be communicated. Then it becomes a promise. And once you have a promise, you should be supported by a consideration. What is the consideration? Some kind of a money or some kind of a value to that. It's called consideration. Then it becomes an agreement. Agreement enforceable under law becomes a contract. So five steps here. So I'll give you a simple example so that you can follow all the 5 steps very easily. I make an offer to you that I want to sell my laptop to you for 20,000 rupees. So you say, okay, fine. You accept the offer. I send you an email that, okay, this is the laptop that I have and I wish to sell the laptop for 20,000 rupees. I make an offer to you. You accept the offer by an email and say, I'm willing to buy. So the offer is made, the acceptance is made, and the acceptance is just not made, but it's confirmed to me. That means the acceptance is communicated back to me. So therefore, it's binding now. Then what is the consideration here? The 20,000 rupees forms the consideration here. That is the consideration. So if the same is executed using my digital and electronic signatures, that becomes an electronic contract. So this is a classical example of an electronic contract. Offer, acceptance, then consideration, communication of the acceptance, and then consideration, agreement, and again a contract. Agreement can be made without signatures also. You electronically agree only over mail. Yes, no, you can do that. But for it to be an electronic contract, I have to use digital or electronic signature. So that's the whole point. So do you now get an overall understanding about the contract? Are you clear till here? Any doubts, any clarifications? Offer, acceptance, communication of the acceptance, consideration, and becomes an agreement, then you can make the agreement into a contract. So this is the whole process. Are you clear on this? Any doubts, any clarifications?
No, Sushanth, we can go ahead.
Thank you so much. Yes.
I have a query,
Please,
Sushant.
please,
This
please go ahead.
electronic,
Please go ahead.
like electronically signed. Recently, we after COVID, we started using more into the electronic signed agreements
Hmm?
or documents or any invoices by
Mhm.
or statement of work. So
Mhm.
how those are categorized? Is there it's
They're all
categorized?
e-contracts. They're all e-contracts. But
Okay.
electronically signed, you must have the electronic signature. See, most of the times, I'll give you one clarification because this is a common clarification that we tend to discuss in corporate workshops.
Mhm.
Do not consider scanned copy of the physical signature as a digital signature. That's a thorough misconception. Because
Mhm.
majority of the times what people do is they sign physically on a paper, they take a photograph or the scanned copy of that photo of that signature, they affix it in invoices, they affix it in emails and all that, but that is not a digital signature, that is not legally valid at all in India,
Mhm.
not just in India but anywhere across the world. So if you want to digitally sign it, you should procure a digital signature and use the digital signature, or you must purchase an electronic signature and then do it. That's also possible. There's no problem. Aadhaar-based OTP e-sign is available for 500 rupees. You can take an e-sign today. You can also use that. And most of the email providers, whether you're using Gmail or whether you're using Outlook or whether you're using any other email service, everybody gives you an option to attach or affix digital or electronic signatures. You can do that simply today.
Okay.
And should you wish not to do that, there are also platforms like Sign Now, DocuSign, which enable you to purchase digital signatures. You can also go ahead and buy them. Nothing bars you from not doing that. But scanned copy is not something that you can call as a digital signature, and it will in no way be legally acceptable if you do that. So
Okay.
get the clarification in that domain. Because I see almost 7 to 8 companies out of 10 using the same scanned copy model.
Mhm.
So they think digital signature means they just copy the physical signature, they take an image, and then most of the times they put that in the offer letters, they put that in the contracts, they put that in the work orders, they put that in invoices and all. But I would say that's a thorough misconception. If you're already doing that, please discard the practice because that's not legally valid, and I can also make the entire document as illegal based on that.
Okay.
So that is the clear distinction you have to keep in mind. So digital
Okay.
signature or electronic signature you can use. There's nothing barring you. You can use it for anything. You can use it for your invoices. You can use that for your say purchase orders. You can use that for statement of works, contracts, MOUs, for internal communication. And if should you have any minutes of the meetings, you can also fix that. Nothing bars you from doing it.
Okay.
And a simple email can work. You don't have to put stamp paper. No need to go ahead and put stamp paper. No need to do anything. If you simply want to communicate, you have a digitally signed email that's equivalent to a stamped document. No need to use a stamp paper at all. So electronic format, you have absolutely the exception, and you can walk away with glory without going ahead and purchasing a stamp paper. No need to invest money, go to the bank or take the franking. Nothing. No need. You can simply execute it electronically. And electronically also, there are 3 models that you can use. The first model is you can use digital or electronic signatures. Second model, you can have click, I agree, I decline. That's also another model. How we sign up on websites, like when you're creating accounts, say you're wanting to buy something on Amazon or Flipkart, you actually try to sign up. When you're signing up, you say, I agree to the terms and conditions. That's again an electronic contract. That's also a click contract. Then you have browse wrap contracts. You're browsing a particular website. They say when you're browsing a particular website, you're governed by these terms and conditions. So the very fact that you have opened the website and you find that there is a policy signifies your acceptance. That's called browse wrap contract. Third one is shrink wrap. Shrink wrap is no longer in use. It was there earlier when we used to go to the physical market, buy the antivirus or the operating system or the Microsoft Office CDs from the physical market. We used to get a sheet attached at the backside, which has some terms and conditions. So the very fact you purchased it from the market signifies your acceptance to the terms and conditions there. That is called shrink wrap. But unfortunately, today we are not even getting into the physical market. Should I wish to buy any Microsoft Office, I can doing that at the luxury of my house, just sitting, paying the subscription amount, and automatically downloading it to a license key. So the concept is totally reversed now. You don't need a shrink wrap at all today. So you can use even a click model. Nothing bars you from doing it. If you have an intranet or a employee-related portal, you can communicate decisions through that, and people accept that and go ahead. And that's also one way you can enforce your policies. Nothing bars you from not doing that. But only challenge is, do not just give them. See, most of the companies or most of the websites rather, they follow a predetermined consent form. What is a predetermined consent form? They give you a checkbox and they just say, I agree. That means you have decided that I'm going to agree. That means you predetermined and said that I am anyway going to agree. But that's not legally going to be acceptable now. I'll have to give an informed consent. That means I'll have to give you the choice whether to accept or reject. So I have to have I agree, I decline, both. So if I decline, well and good, don't provide me services, no problem. But if I accept it, then you provide services, no issue. So that has to be the model that we have to look into, because now the personal data protection bill also has something similar on it. The GDPR also has something similar on it. So they do not accept the click model with the checkbox and just giving I agree, because they consider that as a predetermined consent. Because if should you have to use my services, you have to definitely click on it and use it. Otherwise, you will not be permitted. So that's, you're automatically deciding the consent from my side. So I don't have an option to withdraw my consent. That mechanism has to be avoided.
Okay.
So are we clear on this mechanism concept?
I'm clear. I have one other query. So
Please go ahead.
usually in the network devices and security devices, we put a banner, right? Is it legally agreeable, or it's just a banner?
What
Regular,
kind of a banner? Just give me an example
let's
so that I
say
can.
we'll be putting this is so and so private company property. The users should not log in this, and if they do so, it'll be accordance with the local laws or regulations and the company policies. Unauthorized access, we can call.
No problem for doing that. No problem for putting them. There's nothing barring you from putting them. No
No,
problem.
no, that we can put. What my question is, let's say a company has given, let's say, Race as its router. I'm illegally like logging in into it. Let's say the cyber attack. Okay,
Mm-hmm.
but I
Okay.
have this banner into it.
Okay.
If the
But where is
banner
the
is not
acceptance?
there, yeah.
The acceptance has to be captured. See, merely putting won't help you. So what I should probably do is I should define an asset policy. First of all, whatever asset I'm purchasing, I should have a policy and I should take some kind of an acceptance from people, either by electronically or by physical signature, whatever be it. And despite that, if they do it, you can enforce the same on them, and you can even exercise civil or criminal remedies, whatever you feel like. But
No.
acceptance to that would be very important, because
Okay.
otherwise, just merely
If
leaving it,
it's only
maybe
the banner shows up, no acceptance, nothing, then it's
then
not.
it's again a confusing aspect. See, I can defend again by saying I was never aware of it.
Mhm.
I was never ever aware of it. But if you have a directive or a manual which showcases that these are the do's and don'ts, and then I have to go through that and then go ahead, then nothing. Then I cannot define and defend and say I'm not aware. Whether you're aware or not, I have given my consent. That means the law presumes that you have read. But if you just see, legally speaking, whatever banner you put in, obviously that can be enforced, but there is still a chance of denial. That proof again would be a great difficulty in the eyes of law.
Mhm.
Because what will happen is you might argue and say that the moment you are entering that room, you're bound by the terms which has been specified on the label. That's also possible. We can do that. That also is possible. But again, saying that the banner is not visible, it was not having this, it was not having that, I never looked at it, it was an urgency. So all these could be some pointers that could use as a defense.
Okay.
Then how will I be able to prove? I need to have some undisputed proof so that I would be able to enforce my policy on the other person. That's where the challenge comes. Because actually speaking, the very fact that he has gone there itself means that he is accepting it. No problem about it. But again, the question comes before us is he will say that it is not visible, because the basic quality in a human being is the infirmity that we have to speak to our advantage. See, that is the whole reason why I think the concept of reducing to writing came into picture. Because earlier, if you look at the old times, men or women used to stand by their words. But slowly that concept diminished. People started speaking to my advantage. No, no, I never told all that. Then the concept of embarking on trees came in. People said, no, 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 that is not valid. Then the concept of witness came in. Then I said, no, 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 it is that guy. Then the concept of writing came in. Then I said, so what? I didn't know what was written and what was the content. Then the concept of registration came in, where government constituted an authority, and registration fee was collected, because the state has to run. State cannot just mint money. So one form of state exchequer was getting registration fees. So all these have been into picture because of the quality that human beings have, that infirmity, the quality to repudiate what you told. So that can all be the defense points. So we are trying to better ourselves so that even in those worst scenarios, we are able to at least enforce the policies on the same. But another good approach that you can take is you can just tell them and have a basic policy that should you go ahead and access any of these devices, you are bound by the terms and conditions written there. So that could also be one point you can look at.
Okay.
Choice is yours. How do you want to lead? But this still throws an ambiguous interpretation point, because if I have that as a one that I can speak to my advantage, I can definitely do that. And if your print on that label is going feeble, then that's also another problem. Because see, if you've printed the label today, it's by but natural that in few days slowly the print on it will slowly start fading off. That's the nature of it. No, any label. Tomorrow I can take a defense that the print is not visible. So you should also concentrate on the print of the particular size that you're putting it. An average person, the law always says, average person should be able to read and understand that there is something there. Putting merely something in the fine print does not really amount to a legal compliance. That's what they actually say. That's why even in a website, if you have privacy policy, if you have terms and conditions, we suggest and advise the clients that please make it visible for an average user. Though you're putting it in the footer, don't put it as a fine print. Don't reduce the size of the font, or don't put some color combination such that a person will not be able to understand. Put it in a conspicuous manner that an average person who's looking at your site will be aware that there is a policy here. Whether he reads it or not is a second matter, but at least it's conspicuously visible to him. That's what is the requirement that law specifies. So should your label have all these essentials, we can still enforce the label, no problem. But there are definitely going to be challenges here and there.
Okay, understood.
Right. So any other clarifications that you wish to seek here on this domain?
No, I'm good. Let's continue.
Thank you. Thank you. Any other participants who would like to discuss something on it?
No, sir, we are good.
Great. So I'm also now under the presumption that you are understanding everything, because in law we say presumption is continuing until it's rebutted or unless it is proved otherwise. So that is where I'm taking your word to be the presumption that you are following it. So great. Then we go. I mean, I'm not getting into this composition of cat and all, because cat is no longer there. Yeah. Now some new cyber crimes have got added. This is the problematic affair that I would want to discuss with all of you, because majority of the times I see companies, I see the people who are in the enforcement not being aware of the updated versions. So what you need to be focusing here is the term hacking has not been defined under the present law. The IT Act 2000 had something relating to hacking, but when the act got amended in 2008, we removed the term hacking and we broadened it by saying it is unauthorized access. So unauthorized access is a civil matter clubbed along with a criminal matter, but the term hacking has not been defined. We have removed the concept known as hacking. So this is a very important aspect because I see that the policies of most of the companies, even huge companies, I would say that they constantly use 66 section, which is hacking related sections here. That's why purposefully I have brought into the slide about this particular section. That and the second one is 66A. These two are something which are no longer in existence. So in your IT domain, if I were to say, you are still using Windows XP. Now we are in 10, we are using Windows 11 today. If you're talking about Windows, so you are still interpreting it as Windows XP, which is no longer there, or Windows 2000 for that matter, or ME. It's no longer are available or existing. So in the similar way, even on the internet, why I'm trying to specifically caution you is when you have the open book examination, when you have a question relating to hacking, 99% of the times, though despite I keep telling them in the class, but even in the last batch, I don't want to make it offensive, but just to tell you because I want to even instill that in your mind. Last in the last batch also, I told them several times that please do not refer the old IT Act. Please look at the new provisions, and please understand that when you are interpreting it, remove the term hacking. But 99%, every person in the class nodded their head. They said fine. They said absolutely fine. But when it came to the quiz, when it came to the final examination paper, they still went back to Google and used the same old provisions. So, my dear participants, please uh, understand that we do not have legal definition for hacking. Hacking was there in IT Act 2000 under 66, but that got replaced. That is totally now not a proper section. There's no longer the term hacking defined. We only have unauthorized access relating to hacking, and apart from that, we have computer-related offenses also. But broadly speaking, no hacking is mentioned under the existing law. Second, 66A under the IT Act is struck down by the Supreme Court. Why did they strike it down? Because they found it to be unconstitutional. Why was it unconstitutional? Because it says if you send any messages through any computer or a computer resource, and that message causes inconvenience or annoyance to any person, that is an offense. What do you mean by inconvenience and annoyance? They have not defined it. So if I simply send a message to you saying hi or hey buddy, you say I'm annoyed, and it's causing inconvenience, I can charge you under this provision. So because there's no clarity on what is inconvenience and what is annoyance, so people started misinterpreting this, and people found that this was causing some kind of a threat to their freedom of speech and expression. So therefore, they moved to the Supreme Court. Supreme Court, in the case of Shreya Singhal versus Union of India, declared that Section 66A is unconstitutional, and you can no longer file cases under Section 66A at all because it's no longer existing. So please be alive to that fact. New cybercrimes are also added by the amendment. We'll discuss them in the next session. Yeah, next slide. If you are abetting or conspiring, that means you do not directly participate, but you provide some kind of a conspiracy, then you are also going to be charged under this provision of 84B and 84C. Now, what is the classical example here? If somebody reports to you that there is a problem in the security, you do not bother, you pay no attention to that complaint, and as a result, tomorrow there is an act that is going to take place. You will also be charged for conspiracy because you had the knowledge, you acted in negligence, you did not pay attention to the same. So therefore, you can also be considered as a conspirator for that particular offense. Though factually you have done nothing, but still this provision can be invoked. This is also one important corporate provision that you have to be alive or aware. So if you are aware, please try to rectify it. Please do some corrective action in writing so that you are not charged with this 84B and C for conspiracy. Yes, next slide, please. Yes, there were new challenges that are there. So we have certain kinds of unlimited power was given to the government. Now 69. When we discuss that in the next session, you will be able to understand that. Blocking rules have also come up as a result of the same. So anything which contains any hate speech, defamatory matter, slander, promoting gambling, racism, violence, terrorism can be blocked. So we have the blocking of websites also done by the courts based on these rules, basically. And should you wish to actually have some kind of cooperation from the government, you must exercise cooperation. For example, we have the new IT rules 2021. I'll discuss about that also as we go forward. Yes, can we go to the next slide? Yeah, we also discussed about this protected system. Yeah, please go to the previous slide. Now, I was just talking to you in the morning about critical information infrastructure. Now, the IT Act has come up with something known as a protected system. What do we mean by protected system? The government can declare any company, any network, any particular computer as a protected system. And how can it declare? It can just publish it in the official gazette and say, from this day onwards, this particular computer, this particular network, this particular system is a protected system under Section 70 of the IT Act. So, what will happen if you declare a computer as a protected system? Once it's a protected system, merely accidentally accessing it also gives you 10 years of imprisonment. So, thereby, there's a beautiful provision that the law gives you here. If I, even without any intention to damage, I go ahead and simply access it, I still can be framed for this offense, and 10 years is the minimum imprisonment I can be actually charged with. So 10 years to life imprisonment can be invoked in case I declare, I mean, in case I access a computer which is called a protected system under the IT Act. But unfortunately, it's now been more than 14 years, and till now we have not declared a single computer or a single network as a protected system. The High Court and the Supreme Court, the High Courts of various states, as well as the Apex Court, being the Supreme Court, also mentioned number of times to the government to have this declared as a protected system, but none of them have been acted so far. That's a sad reality. So that's something that I wanted to just share with you. Yeah, can we go to the next slide? Yeah, 78 and 80, I already told you. DYSP to inspector. I'm not getting into that. Yes, next. Technology neutral is already done. Yeah, next slide, please. Yeah, next slide, please. Yeah, please stay on here. So before I get into the other aspects, I would want to talk to you about a very important aspect of IT Act. What is the IT Act speciality? The IT Act speciality is it is a special law. What do you mean by special law? It has an overriding provision. What is the overriding? What is the overriding provision that you have? If there is a conflict between IT Act and any other law which is there being there in force, IT Act will prevail. So therefore, it's an overriding provision. So therefore, it's a special statute. We call this as a chilling effect, because once you have a contravention, let's say that there is a issue, conflict between IPC and IT Act. IT Act will prevail. IPC and some other, I mean, IT Act and banking law, IT Act will prevail. So that's the whole point of why this law is called a special statute. So that's the uh, main one of the key features of IT Act. It has a overriding provision. It's called chilling effect, and it's called a special statute. So do you now get the understanding of a special statute? Why we call this a special statute? I hope you're clear on it.
Yeah.
Any doubts on that special statute aspect? Are we clear?
Uh, Apart from IT Act, any other act is a special
Yeah,
statute?
we do have other acts as well. Basically, we
And
also
if
have. Please go ahead.
yeah, if IT Acts and if there is some amendment in that act which is
Mm-hmm.
in conflict with IT Act,
Mm-hmm.
then it
Then
expires.
definitely IT Act will prevail.
Okay, even though that is also special act.
No, nothing. Because it should pertain to this. If
Okay.
it is pertaining to this, then no problem. If it is not pertaining, see, for example, GST is a special statute.
Hmm.
So, but GST has a limited parameter. That means it's only applicable to GST related matters.
Hmm.
Should there be any conflict, then GST Act will prevail. Likewise, but the broadness of IT Act is Today I'm doing a transaction electronically. For example, let's say that GST Act says you cannot do that electronically. But IT Act gives legal recognition to that electronic transactions. I can still challenge it and say the transaction is valid, but when it comes to the percentage of GST being levied, I mean IT Act has no say in that. But
Uh,
GST law cannot deny that this is not acceptable legally because it is recognized under IT Act. So that is the point I would like to draw your attention to. So should there be anything like that, IT Act will prevail. That's a special statute basically. So despite the fact that we may have any other law which is contravening it, then IT Act will prevail over that. So under Section 81, basically. So that's the whole purpose that I would just wanted to tell you about the same. So I hope you got the clarity on the special statute aspect. Are we clear? Any other doubts, clarifications, or clear? Or please give me a response so that I have an understanding with that you followed.
Okay.
Great. Okay. Now let's move a bit more further. Are you aware of public key crypto infrastructure, or do you want me to get into that?
no,
Yeah.
no, we can.
Yeah, aware, we are aware.
Everybody is aware,
Yes, yes.
because this is an important aspect of the IT Act. Because private key, public key is also defined under the IT Act, basically. And fundamentally, is there's an asymmetric and symmetric crypto system. I hope you have an understanding on it. Same key used for encryption, decryption, symmetric. Two keys asymmetric. So you get the point on that particular aspect, right? Because this is going to be very important as far as the contracts are concerned. Because you are going to use public key infrastructure also, or private key is used for digitally signing. So that's where I said, if you're having clarity on that, then I won't waste much time on that. I just directly go further. Do you have an understanding of that?
Yeah.
Yeah.
Yes, yes, yes.
Everybody, all the participants?
Yep.
Yes.
Yeah.
I heard some voices. Participants, other people who did not respond, please either put it on the chat box or just unmute yourself so that we can clearly skip it and go further.
Yes.
Okay. Pranav, next slide. Yeah, next. Yeah, please wait. Please wait here. Please just go to the previous one. Yeah. So I was just talking to you about the different authorities under the IT Act. So one of the authorities that we have to remember here is controller or certifying authorities. So it's just like the concept of a organization itself. Just like how in an organization you have the CEO, then you have the vice presidents, you have the other employees being appointed. On the similar ground, we have an authority here, which is the controller. Just imagine the CEO to be your controller. So controller of certifying authority appoints the certifying authorities, and certifying authorities provide certificates with respect to digital signatures. They issue the digital signatures basically. So that's the hierarchy that you have to look into. Controller, certifying authority, and the subscriber. So you're clear on this? I'm giving you a very bird's eye view. I'm not getting too much into the intricacies. So you're clear on this area? Controller, supervises and appoints, then certifying authority who issues, and subscriber who ultimately subscribes to the same by purchasing it from the respective certifying authority. This is the whole hierarchy. Yes, next slide. Next. I'm not getting to all these things. Yeah, next. Yeah, please go to the next. Yeah, now comes the very interesting provisions of the IT Act. So this would be some things that you'll have to primarily focus on because this is going to be useful even from your professional perspective. So these are three different sections, which I would call them as corporate provisions because they're going to be very, very important just to understand and determine, the receipts, the acknowledgements, and also the attribution, and also the place and time of electronic records, because these are some things that are likely to be even applicable to your corporate communication. So this is where I just wanted to bring in the emphasis so that you're very clear upon what's the exact perception of the law. So these three provisions I would want you to be focused on, And these, even from the examination perspective, I would like to tell you that there would be a lot of questions from these domains, because these are some areas which I feel are a little confusing, but at the same time, if you get the logic, then you can crack them very easily. So therefore, please try to stop me and then discuss if you have any, clarification, so that we get these points right. So number one, the first thing is, how will you attribute an electronic record? So attribution is very, very important, because if I am to say that I am the originator of this particular electronic record in the eyes of law, there's a dispute tomorrow or there's an issue tomorrow. How will you attribute the electronic records? Electronic records can be anything. Just take an example for that to be an email. So email, because that makes it very easy for us to interpret this provision. So an electronic record can be basically attributed in three ways. One, if the originator himself sends it. So first, let us clarify who's an originator, who's an addressee. Originator is the person who originates the message, and the addressee is the person to whom the electronic record is addressed to. So in our scenario, let's say, for example, you are submitting an assignment to me. You become the originator, I become the addressee. So getting the point. And who's the intermediary here? Gmail, if you're sending it to my Gmail account. So Gmail becomes an intermediary, which is the service provider here. So I hope you got this understanding. Originator, addressee, and intermediary. Are you clear on these three aspects? Any doubts? Any clarifications?
Yeah.
Okay. Now, if you want to attribute a particular email to me, how will you attribute? So the three ways are there. First thing, I directly send an email to you, no problem. I have directly sent it myself, no problem. I authorize somebody to send it on my behalf. Then also, it is not the person who's been authorized, but it is the originator himself who will be attributed. Third, if there's an automatic system that have been that I've configured to operate on my behalf, that also attributes to me. I'll give you a classical example here. Now, one classical example is you're working in organizations, right? So if you send a mail directly to your respective client or the respective customer, you become the originator, your customer or the client becomes the addressee. And whoever is your email service client provider, they become the intermediary. Okay, first part is clear. If you send it directly, if you're asked to send a particular piece of email from to a particular client, you send it directly on your behalf. There's no problem, because the email is originated from you. You become the originator, and that email is an electronic record that is attributed to you directly. No problem. No issue at all. Suppose you got a team member, or you got let's say that you got your colleague. So you authorize a team member and say, on my behalf, since I'm not available today, you send it on my behalf. Even if the mail is sent by the person who's your team member, it is originated from you in the eyes of law. It's not originated from him. So the originator, so that document is attributed, that electronic record is attributed to the originator. That's the second part of the story. Third part of the story, most of the times when you have these corporate emails, let's say you're on a holiday, you're on leave. The moment, let's say that I send an email to you and you're on leave, it says, thank you, I'm having limited access to the internet and I'm on leave for so and so days. You can contact that person. I'm sure you would relate to this. Automatic messages. Even automatic messages means that the originator is you only. I mean, the addressee is you. I mean, if you have that particular one, it can be attributed to you only, not to the system who's giving you that service. So therefore, be very clear of these three facts. So originator is attributed for an electronic record in three ways. If it's sending directly himself, or if he's authorizing it and then somebody else sends it on his behalf, or if it's an automatic message. So in these three cases, the message is supposed to be originated or attributed to the originator himself. Are you clear on this?
Um, so anyhow, whoever is actually sending is, that will be the originator, right?
Yeah, but if you are authorizing someone to send it on your behalf, then even if it is sent by that somebody is not going to be coming into picture. You will be considered the originator.
Okay, but if somebody is not having proof of that,
No
say
proof,
some-
nothing. See, that's where we say we have this second clause very clearly. See, a person who had the authority to act on your behalf. That's
Okay.
where we are trying to say. If you're not authorized, then there is no problem at all. Then it's going to be originated from that person only, not from you.
Okay. Okay. Got it.
So this is the common problem that we are going to face, because most of the times what happens is, if you're in a team lead position, or if you're in a position of managing a particular team, sometimes you might want you might be asking one of your team members to do it on your behalf, on behalf of the team. In that, it's going to be not him, but it's going to be you who's responsible for the team, who will be the originator, but not him, because he does not have the authority to do so. You are authorizing it on your behalf, and then you're doing that. Should somebody do that on your behalf based on the authority that you designate to him or her, then that origination is going to be you. But without authority, if they do anything like that, then that attribution will be to them and not to you. So authority is something that is going to be primarily looked at. So are we clear on this? Attribution in three manners. Directly you send it, no problem. Somebody you designate, you authorize somebody to send it on your behalf, then that somebody will be sending it on your behalf, but originator will be you, not that somebody. Third, if there's an automatic message, then the originator also would be you. So it can be attributed to you, right? Not to the person who's writing the program for that automation, not for the company in case you're using an external third party tool. Please get that point correct so that you do not miss out. Because like I said, the perception has to be analyzed in the way of the law, but not from a technical perspective. So please be aware of these three cases. Attribution, in these three cases, I can attribute. So any clarifications, any doubts, or should you want me to go ahead and explain with another illustration? Just let me know so that I get an understanding. If you're clear, please let me know so that we move forward to it.
Sushanth, can we repeat the second one? I'm still confused about it. The
Okay.
originator part, if somebody asks. If
Okay.
authorized person is fine, but if
Okay.
somebody asks and
See.
somebody is non-authorized.
Okay. Now let me tell you.
Hmm.
You are authorizing your team member
Hmm.
and telling him that I am authorizing you to send it on my behalf. Since I'm busy or not available, you send this on my behalf. That person sends it because you have authorized him to do it. Okay. Then the originator of the message will not be the person who's sending it. The originator will be you, because you have authorized him to send it. He has not sent it directly. So it is
Hmm.
originated from you, not from him,
Hmm.
despite the fact he is sending.
Hmm. Hmm.
But if the person does not have any authority from you, suppose you do not give any authority to him, but he sends it without your authority or without your permission, then the originator will be him, not you.
And this authorization, how
Hmm.
it will be recorded? My
You have to
question.
put it either in mail, or you'll have to
Oh.
provide some document or something like that. See,
Okay.
mail also will be fine. You
Hmm.
say that you authorize him and say you send it on my behalf.
Hmm.
So a
Hmm.
simple mail can be done.
Hmm. Hmm. Okay. Now I got it. Okay. Yeah.
So then you will be the originator, not him.
Hmm. Hmm. Hmm.
Despite the fact he's sending, technically he's the person sending it.
Hmm.
So technically he's an originator in technical terms, because he's sending the mail.
Hmm.
But in the eyes of law, it is not the person who's sending it, but it is you.
Hmm.
So that is where I said, please understand with the legal mind, because
Yes.
that's the interpretation we have to look at. Because usually what happens is, if a question is posed to you that a team member sends a message on behalf of you to another team, normal tendency what we do is we put the originator as the other party because you are not sending it.
Hmm.
But that is where you'll have to keep in mind that legally speaking, the originator of that message will be you, not him.
Hmm. Hmm.
So despite the fact that in the practice he is doing it, technically he is doing it, but really in the eyes of law, legally and technically there is a difference.
Hmm.
Technically you are right in saying he is the originator, but legally you are wrong, because you are the originator and not he, because he's doing a postman duty to you. That's it. See, another example to tell you is a postman. See, today you are sending a courier. Let's say you are sending a courier to me from Bangalore. You go and go to a courier office. You send it to me. You send that particular courier, you hand over the courier parcel to some employee there. Let's say that that employee will be a part of a courier company. He'll come and pick it up and then go. Amazon delivery boy, a classical example. Your Swiggy or Zomato delivery boy. They're all guys who are acting with authority. They're not doing something on their own. They're authorized by Swiggy or Zomato or Amazon for doing that activity, right? So they technically they are delivering the product, but the product and the order is delivered from where? It is delivered from Amazon or Swiggy. It's not delivered by the person individually. You get the point, right?
Yeah, yeah.
So this is the fact you have to remember. Whenever you have a doubt in this, try to go back to this example of Swiggy and Zomato because I feel that's the classical way of remembering it. When you place an order through Zomato or Swiggy, the delivery guy comes and delivers. You are not bothered whether he's a full-time employee of Swiggy or he's a contractual employee. That's not your concern. Your concern is you have placed an order and he has come and delivered it. He has come on behalf of an authority. Who is that authority? Swiggy. So if the delivery guy does some problem tomorrow, you are not going to take this guy to task. You will take Amazon or you will take Zomato or Swiggy to task. Correct?
Yes, yes, yes.
So why are you doing that? Because it's originated from them. So that is the exact understanding you have to keep in mind when you talk about attribution. Are we clear on this?
Yes, sir, we are
Ah,
good.
great, excellent.
Sir, can
Now
we take a 10 minutes break now?
done. We catch up at 3:20 back again.
Yeah, sure.
Sure, sure, sure.
Okay.
In another 2-3 minutes, we'll start. Participants, are we ready? Can we catch up?
Yes, sir, we are back.
Great. So I hope you're able to relate to whatever we are discussing now. Okay, let's go. I mean, I'm presuming that there are no clarifications required in this. Let's go to the further one. Yeah. So now let's further more talk about when do you consider an acknowledgement of receipt? Now, all along we talked, we spoke about the originator. Now let's talk about uh, acknowledgement of receipt. So when you have a particular originator, and when the originator has not stipulated that the acknowledgement of receipt be given in a particular format or particular method, then there are two ways of receiving acknowledgement. What are the two ways? One is any communication made by the addressee, whether it's automatic or otherwise, or any conduct on the part of the addressee to ensure that the particular electronic record has been received. Now, let's take an example. Now, I am the originator and you are the addressee. Now, I tell you that I'm sending a mail to you, but you need not acknowledge it in a particular way. So, what do? You just communicate with me and say that I've received. I'm not given any kind of a, I've not stipulated that acknowledgement has to be done in this particular form or manner. Then you can give me acknowledgement in either ways. Either you can directly communicate to me and say that you received it, or automated also you can say. Automated means the moment it is reaching your inbox, an automatic message can be sent to me saying that thank you for sending the mail, I'll get back to you shortly. That also is considered to be a communication on your part. Any conduct on your part, that means if I talk to you about some activity and you conduct yourself in such a manner that it is corresponding to the mail content, then therefore that is also enough, or that is also sufficient to establish that you have received that particular electronic record. So are we clear on this? When the originator has not stipulated any particular acknowledgement of a particular of the electronic record, be in this form or manner, then the acknowledgement of receipt can be done either by any conduct or by any communication by the addressee. Are you clear on this? Any doubts, any clarifications? Please give me a response so that I am aware that you followed. So if I don't stipulate and say the acknowledgement has to be given in the particular form or manner, and then when is it? How do you acknowledge the receipt? Any communication made by the addressee whether automated or otherwise, or any conduct on the part of the addressee. Any of your conduct also is sufficient to indicate that you have received it. So that's what we are trying to say. Please give me a response. Are we clear or not?
Yes, sir, we are good. It's
Great.
just a simple of for a mail when we sign
Yeah,
for the
it's not only mail but
postman.
any electronic record.
Yes, sir.
It's
So
not only
this
a
is
mail
just an
but any.
example.
Yeah, this is just an example that I just try to give you. See, I am the originator, you are the addressee. I don't specify and say the mail has to be acknowledged like this or in this manner. Then how do you deem the acknowledgement? If you communicate to me either directly or through an automated message, that communication is enough. Then any conduct that you do, for example, you call me and or you just respond to me on based on the content of the email, that also is presumed that you have received the mail. So these are the circumstances which the law presumes that you have received and you have acknowledged that particular electronic record. So are you clear on it? In case I do not specify and stipulate that acknowledgement be given in this form and manner. Yes, please go to the next slide. Pranav. But if I stipulate and say that it is going to be binding only in case you send me an acknowledgement, and then acknowledgement has not been received, then it is presumed that the electronic record has never been sent. So two cases here. The first case that I would like to tell you is where I don't stipulate of any acknowledgement. Then I say don't need to acknowledge at all and don't need to even send it to me in a particular form or manner. Then when is the acknowledgement going to happen? Either when you communicate to me, either directly or otherwise through an automated means, or in case you send in case of any of your conduct. Now, second, in case I say that this electronic record will be binding only once you acknowledge it, and if you don't acknowledge it, that means it is presumed that you have never received it. Are you clear on it?
Any example of this?
Okay. Suppose I say I am sending you a mail now, and that mail is going to be effective only in case you acknowledge it. So you do not acknowledge it. That means it is presumed that I have never sent a mail. Yeah, that's the point. Because I have stipulated acknowledgement as a condition for it to be binding. So that's why you see the stipulation of acknowledgement will be something we have to really look into. Suppose I stipulate and say there is no need to give any acknowledgement, then the first case will come into picture. If I say it will be binding only if you acknowledge it back, and if you acknowledge it back, fine. Otherwise, it is the legal presumption is I have never received it. That means I do not have I have not have sent it also in the eyes of law. Though technically I might have sent it, but legally it is not binding. It is going to be only binding in case I send the acknowledgement. So that is the fact you have to look into. Are you able to relate now?
Yeah, yeah.
So clear with both the cases. In one case, if I don't stipulate that acknowledgement has to be done, and acknowledgement even the form and manner also I don't specify, then acknowledgement is going to occur in case you communicate to me or in case you actually try to do any of I mean any conduct of yours is enough. But if I specifically say that you have to acknowledge it, and only upon the acknowledgement this document or this electronic record will be binding, and then you do not send me an acknowledgement, then it is presumed that such record has never been sent by me.
Similar
Hmm.
to offer letters and all, right?
Yes, similar to offer letters. But this is absolutely the point that we are talking specifically with any electronic record, not
Yeah,
only
yeah,
a PDF or an
yeah.
offer letter, but any document, any electronic record, even a mail, a simple mail, or a document, or a chat, anything. For example, a lot of times when we send emails, we tend to send a message to people, right? We have sent a mail, or they'll ask you that we received a mail or not. This usually happens in our day-to-day activities also.
Yeah,
Once we send a mail, we drop a message to them on the mail or on the message or on WhatsApp saying that a mail has been sent. So they will also acknowledge and say yes, we have received it. If they have not received it, they'll again say, no, we didn't receive it. This is a common practice. But in the eyes of law, this is the acknowledgement that you can derive upon. Both these cases. So now you're clear on these, you're clear on the attributors also.
Yeah.
So any clarifications with regard to these two aspects? If not, then we'll proceed further to the next one. Yes. Pranav, please go to the next slide. Now, the originator has not stipulated that it is binding only on receipt. However, the acknowledgement has not been received by the originator within the time specified or agreed, or if no time has been specified within a reasonable amount of time, then the originator may give notice to the addressee stating that no acknowledgement has been received by him and specifying a reasonable time limit within which the acknowledgement has to be received. If no acknowledgement is received within that time period also, then he may, after giving the notice to the addressee, treat that the electronic record has never been sent. Okay, let us break it down part by part. Now, I am the originator, you are the addressee. I don't tell you that you have to send me an acknowledgement. Only on receiving acknowledgement, this record will be binding. I don't tell you that. But, however, you have not responded to me within a certain time period. If I say within 10 days you respond, I have not responded, you have not responded to me. Or if there's a lapse, 1 month is passed, 2 months is passed, there's no information from your side. So what do? I will have to send you an mail once again that no acknowledgement has been received. Kindly acknowledge it within 1 week. Now you will not receive, you will obviously not respond to that also. If you don't respond to that also, it is presumed I have never sent it to you. But if I respond, then fine, no problem. So this is the fact. So I'm once again going through this particular clause once again. I am the originator and you are the addressee. So I do not tell you anything about the acknowledgement. I tell you that even whether you acknowledge it or not, it has nothing to do with the binding. But you have not sent me any acknowledgement till date. Suppose I sent it to you 10 days back. You have not replied to me. I have not received any information or acknowledgement from your end. I don't know whether you received it or not. So I'll once again drop a mail to you stating that I have not received any acknowledgement time. It's been quite some time. So please reply back within some period of time. Let's say within 4 days I asked you to reply. You don't reply to me after 4 days also. Despite this, then what am I going to say? I'm going to tell that I have not received a response from you. So therefore, I'm presuming that I have not sent it. It has never been sent. Second, if I suppose reply back, then there is no issue at all. But if I don't reply, the question that comes here is, are you clear on this now? If I am the originator and you are the addressee, I know I make no specification that this will be binding only on acknowledgement. But however, you have not sent me an acknowledgement. I have not received any acknowledgement from you, despite 2 months, 10 or 3 months or whatever be the time period. If I have specified a time period, within the time period. If no time period has been specified, then within a reasonable amount of time. Reasonable amount, maybe 10 days, 1 week. You can interpret it the way you want. Then, if that is also not, no acknowledgement is given from your side, I mail you again and say, I have not received any acknowledgement. Kindly acknowledge it. Now I have to specify a time period. I can't leave it open. I have to say within 3 days or 4 days or 1 week, you respond back. If you respond back within that day, fine. Then it is an acknowledgement. No problem. But if you do not, then it is presumed that I have never sent you. Are you able to now understand what I'm trying to say? Participants, some feedback. Are you clear? One another illustration or what? What? Please let me know.
Quite confusing. I would
Yeah.
be thinking twice now while replying emails and receiving emails. I
This
might
is where
refer
I said.
IT.
This is where I said it will be confusing, but you will have to understand the logic. See, first try to understand the logic. The logic is two things. First thing, when let us go back and look at the first part of the story. First part says that I have not stipulated that it is binding only on acknowledgement. Okay. Then I have not received the acknowledgement within the time period. If I've specified the time, there is no time period within reasonable time period. Then again, I drop a mail to you saying I have not received an acknowledgement. Since I have not received an acknowledgement, I'll ask you to send me an acknowledgement within a time frame which I specify. Suppose I receive the acknowledgement within that time frame, well and good. Suppose I don't receive it, then the law says I have never sent you that at all. So this is what I'm trying to say. So think that you're actually trying to do it just like your communication happening in your company. In your company, you may say you want to have an acknowledgement. So if you get an acknowledgement, fine. See, use most probably this happens with the finance teams, right? When you send an invoice to them specifically. Now, suppose let's say that client's invoice is pending. What do you say the client? You tell a client send your invoice. Now the client says, okay, I'm sending the invoice. I've sent it. Now he does not talk anything to you saying that unless you acknowledge, the invoice will be binding. If you don't acknowledge, the invoice is not binding. There's no communication with respect to binding. He just says, I have sent you, but you have not received it. You have not acknowledged it back. So he will say, boss, have you received it or not? Please give me some acknowledgement. It's now been more than a week. Now he will say, please reply back within 2 days whether you have received it or not. If you are replying back, fine. But if you don't reply within the 2 days also, it is presumed that you have never, he has never sent you the document. That's what they're trying to say. So the logic would be based exactly on the same. So when the acknowledgement is not stipulated as binding and no acknowledgement has been received despite the fact, then I have to send him a reminder and say, please acknowledge it within so and so time period. Here, in the first instance, if I don't mention the time period also, reasonable time is enough. But in the second instance, I have to be very specific. I can't let go a general word here. I have to tell them that since you didn't receive, since I did not receive any acknowledgement from you initially, at least now you would respond by giving me an acknowledgement within this time frame. So within the time frame, if an acknowledgement is received, fine. If it is not received, then it is presumed that I have never sent you that. You're getting the point, right? So three aspects of the
Yeah.
story. You have
So
to look
I
at.
have one example. I'm not
Please,
sure
please,
whether
please
it's
go ahead.
here.
Go ahead.
So suppose employees' notice period was 30 days in
Okay.
one company, and in
Okay.
all employees' offer letter, it is 30 days.
Okay.
Then company is mailing to candidates individually. In two
Okay.
candidates' email ID is there. With
Okay.
effect from 1st of April, your notice period is 90 days. Even
Mm-hmm.
if you don't accept, it is
Mm-hmm.
effective from 14th of April.
Mm-hmm. Mm-hmm.
So now some violation is there or some fishy thing is there. Can you
Fishy thing
please?
is definitely there here. Whom are you addressing to first?
I am addressing to company.
No, no, no. You told me that the company is sending mails to two employees.
Two in employees email ID is in two. Means sometimes they'll send in BCC, sometimes they'll use a group ID. But in
Okay.
this case, they individually mail like
Okay. Okay.
park.acharya@xyz.com.
Okay. So make your question simple. See, a company is sending a email to the employee informing them about the notice period. That's what you're trying to say.
Hmm.
And originally, the notice period in the contract is 30 days, but in the mail, it is 90 days.
Correct.
Right? That's what you're trying to say. And now, what is the condition that I put in the email? That is going to be very important. Suppose I
Uh,
say, now it is going to be binding only if you acknowledge it. Then the second clause will come into picture. Suppose I have not specified anything about the acknowledgement. I don't say that it is binding only on acknowledgement. Fine. But the employee does not respond back within 10 days or 15 days or 1 month. The company will have to reach out to the employee once more and say, I have sent you an email. I have not received any acknowledgement from you. So kindly acknowledge now within next 4 days again. So
but
if the
nobody will
employee,
acknowledge. No,
nobody will
nobody will
acknowledge. So
acknowledge.
then it
Yeah.
is presumed that
Hmm.
the mail has now been sent.
Correct. Then on what
So under
grounds
this,
the company will reject the resignation and they'll say you need to serve 90 days?
sorry, I didn't get your point. There was some background noise. I think there's some background noise happening.
Yeah. Now is it audible?
Yeah, now it's clear. Please go ahead. Now on
So
what basis?
on what basis company will reject the resignation for 30 days and they'll ask to serve 90 days? and it is not in the contract, nor mail is acknowledged,
So
nothing
that
is
is a
there.
different matter. That is a different matter altogether. See, notice period cannot be increased and decreased as per the discretion of the company. There is a clear cut violation of the labor code. It's a different matter altogether. The labor law does not allow me to send notice period to change the notice period according to my own will and fancy. If I want to, should I wish to change the notice period, I will have to take the consent of the employee and then do it. Because the contract says
Correct.
one termination, one notice period. I want to alter that notice period which is there in the contract. So therefore, it is amounting to change of the condition in the contract. Any change of condition will have to be accepted by both the parties. Otherwise, it does not seek any effect. See, that is why you see any company policy, they will ask the employees also to give their consent. Otherwise, the policy does not have any effect. That's why we always have an
Yeah,
amendment clause in
that's
the
why that
agreement.
company is issuing the revised offer letter.
Revised,
to
but
all
that
the
revised
employees.
offer letter, no. Even if it issues a revised offer letter, that revised offer letter has to be accepted by you. If you don't accept it, the company can do nothing about it. I'm
Yeah,
telling you
then
this out
it's
of
good
personal
for
experience
employees.
because we fought for even for employees.
Yeah, fortunately, I was not caught
No,
in
no, not
that.
that you are there, but see, we
I
had both
was
the
there in the
experiences as
company,
a
but
company.
I was able to, get relief in 30 days as per the offer letter.
Hmm,
I didn't acknowledge the mail.
hmm.
So I
But it's
told this.
already no, but it's already an established fact that your contract has been signed. You must have gone through the contract definitely. When you sign, it is presumed that you are aware of the same. Basically, you are
Yeah,
aware of the notice period. It is presumed. Legal presumption is when you accept and sign, you have read it. Whether you have read it really or not is a different matter. The law will not look into that. The law will look into the moment you sign it. It presumes that you have read the terms. So if the notice period is mentioned as 30 days, then automatically you have signed. That means you have signified your acceptance for 30 days. Now, should the company want to alter this notice period, it has to now change and issue a revised letter. And the revised letter should also be signed equally by you. Should you not wish to sign it, the company cannot enforce it on you because it's again a unilateral decision. Because an agreement is when both the party agree on the same sense in the same thing in the same sense. We call that as consensus ad idem. We call that as consensus ad idem. One classical example, because you bought this in the discussion, I'll tell you. Let's say that we have two laptops with me. One laptop is i7 processor or i9 processor. The other one is an i3 processor. So now I tell you that I'm offering my laptop for sale, and the laptop is only 10,000. Now you think you do not have an understanding that I have the i3 laptop also. You only know that I have the i7 or i9 laptop. Now you think it is a wonderful opportunity. Are i7 or i9 processor, I'm getting the system for 10,000 rupees. It's a throwaway price. You agree for it. But originally, I am offering not the i7 laptop, I'm offering the i3 laptop. Then what happens? There's no identity of mind here. Why? You have agreed on something, I have agreed on something. So there is no meeting of your and mine minds together. So we are not agreeing on the same thing in the same sense. So therefore there is no consensus ad idem between you and me. So therefore the contract is not legally enforceable because we did not act upon the same thing in the same sense. So in the similar matter, even it comes to notice period also, the same thing would be applicable here. So especially notice period alteration involves a lot of legal processes because it has to be signed by the employee. If the employees are not willing to accept the new notice period, then the company can do nothing about it. Merely sending a revised letter or a policy won't be of any consequence legally because I have to take the consent. If I don't take a consent, where is the consensus of ad idem here? Nothing. I am not agreeing at all. So that is where we can challenge that. In fact, we did that for some employees and got them reinstated also in some cases. So that's the we had both the experience. We fought for the companies, we fought for employees also. COVID time, we fought for almost say 8 to 10 employees. We got them reinstated also because of some technical issues, let's say cost cutting or whatever be the blah 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 reasons that they have stated based on COVID.
yeah,
We
this is
got
a
them
very
successfully.
interesting issue.
Because see, that's where even in the morning I told you, COVID-19 brought a lot of litigation in picture because companies were not able to meet the expenditure of employee salaries. So they started therefore terminating employees because they were unable to meet their overheads. But you cannot do that just because you cannot meet your overheads. So the fact remains is proper termination has to be done. If you do an illegal termination, I can still reinstate the employee back because the labor law gives me an option to do that. I can go to the labor commissioner, I can get a notice issued from his end first, and then I can call the company to the labor commissioner first, then I can go to the labor court, and probably a lot of things are there. But it nothing basically can be done by the company thereof.
Correct. And one company, I don't remember the name, they fired thousands of people in Zoom meetings.
Mm-hmm. That is not
So
legally
that,
viable. See, because see,
yeah,
you cannot do that because there is no ground. See, ground of termination is something that is very interesting. That has to be looked into, basically. See, the fact remains is, I tell you one case what we fought. I will not tell the name of the company, but the name of the employee as well. There is a performance issue. The company was, we know pretty well that it's a blatant false statement made by the company. The company told that there's an underperformance of this employee. Therefore, before performance on the basis of poor performance, we are terminating the employee. So we took the contention that no warning material or mail was issued. First thing. Second, let's say that even if you have not done the warning mail at your end, okay, where is the proof to establish that the performance was not adequate? Is there, do you have a PIP or a PEP in place? There's no PIP. Has the employee been put on the PIP? No, he has not been put in the PIP. Third, have you deducted some amount of salary based on the performance issues? No. And what does your offer letter say? The offer letter says that I will be paying you full salary in case your satisfactory performance is there. That means just because my performance is good, you are paid the full salary. That means you acknowledge the fact that my performance is good. So where is the question of now you claiming to be poor performance? There is nothing that the company could do. And it reinstated. We challenged them saying that it's an illegal dismissal. Should you not take it back at a legal notice level, we'll proceed to the labor court and then or we'll also go to the high court and file a writ that my fundamental right has been breached. So therefore, we'll go ahead and seek a legal remedy. Ultimately,
but
after 10
in
days,
these
the discussion.
cases, but in these cases, this employee's life would be not the same as before, right? Company will anyway torture him.
No, let them torture, but they are obligated to make full payment. And based on this, if they're tortured, we can again seek legal remedies, basically. So that is where the challenge is now. And today you see the latest happening, which is happening in Infosys now, the hue and cry that people are facing, the non-compete laws, which totally, mentions that the employees who quit Infosys cannot join competitors. For example, they cannot join Accenture, they cannot join TCS,
But
Wipro,
for
and things
same
like that.
client, no? Is it for
Sorry?
same client? No? It is for
See,
same client.
I totally get it, but the fact remains is that all these things are restrictive covenants under the contract law. What do you mean by restrictive covenant? Restrictions should be fair and reasonable, basically. Just because you have a client, that doesn't mean that you put everything like this. For example, see, a huge company may have 100 clients. So just because I'm having 100 clients doesn't be legal for me to emphasize that my employee should not go and join my client. I can have it to a certain level, but not every level. So that's where the challenge is because it's non-compete as such is not valid in India because it becomes a negative covenant. Even if it ought to be interpreted, it should be in a fair and reasonable manner. It is not in the fair and reasonable manner according to these people's version. They say it is hampering the particular person's life because these are huge companies. So we are yet to await what could be the probable result, but it's going to be an interesting decision that can come in that matter altogether.
Yeah, in and around some restrictions are there. Like I'm
Restrictions
working in
have to be
Capgemini.
reasonable. See, restrictions have to
Yeah,
be reasonable, but cannot be in a way which is trying to make excessive use of power cannot be done by any company. Because see, for that
yeah,
matter, the developers, see, most of the companies, what they do is in their employee agreements, they include these clauses relating to non-compete. They say you should not go and join a competitor. Now, my question to them is, suppose I am a developer, right? Or I'm a tester. My job is to test applications or my job is to develop applications. And any IT service company can be a competitor to another IT service company because it can offer similar services. So how can you emphasize that to me and say you should not join a competitor? The competitor may be any company, who's providing IT services. Second, you should not perform similar services. This is my bread and butter. If you ask me not to provide similar services, how can I not do that? That's affecting my fundamental right to practice any freedom or trade, and right to also do any kinds of activities. That's the right to have any occupation. So who are you to challenge and tell me that? You have no business to do that. So therefore we did that on behalf of some employees also, and then we correct those when we are drafting out employee agreements for companies. They come to us for consultation or other things, because these are some pointers which should be very properly crafted and worded in such a way that the letter and spirit is covered, but at the same time you don't breach or you don't come in violation with any of the laws in being enforced. That's the major drawback. Otherwise, the challenge is going to be a different matter altogether. Even security related, see, we had a client, I don't want to name, but who was asked to actually do maintain the cyber security of one particular client of mine. And these people, as part of that, they try to do some kind of a activity. Like, for example, pen test was done, but pen test was done without a proper agreement and documentation. So that's why we caught them. We said, how can you do that? It's not covered with a document or an agreement. Where's the scope? Where's an authorization? Where's the kind of clauses which are pertaining to confidentiality and things like that? Where are they? Nothing was there. We were able to sue them for damages, and then ultimately they came for a compromise. We settled with great amount of negotiation therein. But these could be the probable challenges, because as a security practitioner, you must also be aware of what you should and what you shouldn't be doing. And if you are executing a particular security related activity, you must ensure that there's a proper agreement defining what is the scope of the security related activities and what is not covered, because that's going to really determine whether you have done a thing in your good faith, or you have done something violating any particular legal principle. So that's something we have to be very clear of. Mere doing something, having a small document won't be of help. You should have a document which totally covers all these areas. Otherwise, there's going to be challenge that we can face tomorrow from a legal perspective. That's another kind of awareness. In the morning, we discussed awareness at various levels. This is also one kind of an awareness which people in organizations are lacking today. Even the IT policies, you just see they cut, copy, paste. And especially with companies who are having websites and mobile apps, it is even more comedy for me, because they copy terms and conditions to such an extent they don't even change the names. I've seen so many cases that way come to me. They one such case that had come to me of one gentleman who has a very high reputation in the startup ecosystem in Hyderabad. I'm not naming him, but a very reputed guy who even works with the IT ministry of the state, and then he's a very respectable guy in the startup ecosystem. So he came to me and said, "Why should I require a specialized, cyber lawyer? I can get it done with any lawyer. I have a legal team." I said, "Fine, excellent. What do you do?" Then he told me, "We are into e-commerce activities, and this is what we do." I said, "Please open your website." He's opened. Then he showed me with pride, saying, "We have privacy policy in place." I said, "Excellent. Please open the privacy policy. Please open the terms and conditions." He opened the terms and conditions. Then I said, "Please go scroll down." As I was seeing, I just could not control my laugh, and then I was kind of what do you say, rolling literally on the floor and laughing. Then he asked me, "What's the reason?" I said, "This is a cut, copy, paste from Flipkart." Then he said, "No, no." Then I said, "Look at the 17th point over there. It says in case of a problem, Flipkart will sue you." So that's the blatant copy of how people have done terms and conditions today. I'm happy that awareness is there that they should need privacy policy and terms and conditions, but I am not completely happy about the awareness, because they do not have awareness of what should or what should not be considered as a part of these policies. That's where the problem is. Merely having a policy doesn't have any consequence. But if you do not have the essential elements in the eyes of law, though you have it, it's presumed you do not have it. That is where we are trying to talk about this as well. So that's why I related that to an example, so that you can understand the practical implication. This commonly happens in terms of web and mobile policies. Because that's also one of the other activities that we do as part of our consulting operations. So this is the problem that we have found in majority of the places. And some places they don't change the names also. That's the biggest drawback. And forget they complying. They are now violated because that's a copyright again. Again, intellectual property infringement can be done by Flipkart. So that's a matter which is entirely different. But just to tell you that these are the all different issues that people tend to do with ignorance, but ignorance of law is no excuse. So that's the whole point of our Indian legal system. Ignorance of law is no excuse in the eyes of law. You can't tell that I am not aware of such and such a law, so thereby I have committed this act. No code of law is going to accept that. So you don't need to be a lawyer to know that, but just like how you are driving on the road, you should be aware of the do's and don'ts. Likewise, when you're using computers, computer systems, or computer resources, communication devices, data or information in the electronic format, you should have basic understanding of cyber law. That's why the subject has got such a vast and huge potential and scope. So that's the reason I wanted to just share out these experiences also with Abhi. So are we clear on these aspects? Attribution is one scenario. Then the first case, in case I say acknowledgement is not binding, then acknowledgement is presumed to have happened in two cases: when it is communicated by the addressee, or when there is any conduct on the part of the addressee. Second, if I say that the electronic record is only binding on acknowledgement, if I don't send an acknowledgement, it is presumed that the electronic record has never been sent. That's the second part. Third part is, if as an originator I do not stipulate that the electronic record is binding only on receipt of acknowledgement, and if acknowledgement is not received within the time specified, or if there's no time specified within reasonable amount of time, then I have to again send an email, an intimation to the addressee, asking the addressee to send the acknowledgement within a specified time period. If it is not received within if the acknowledgement is not received from the addressee within that specified time period, then I will presume that the record has never been sent by the originator. That's the whole point. Are you clear on these three areas now? Any doubts, any clarifications? So I mean, I'm waiting for your feedback, participants. Are you clear? Any
Yeah,
doubts?
Yeah,
we got
yeah.
this.
Great. Now let's go to the last part, which is called time, place, and dispatch of dispatch and receipt of electronic records. So now we discussed about acknowledgement, we discussed about attribution. Now let us discuss about the time and place. Now, save as otherwise agreed to between originator and the addressee. When does a dispatch of an electronic record occur? It occurs when when it enters the computer resource outside the control of the originator. So therefore, I presume that I'm sending you an email. Let's say that I send you an email. The moment I press send, it's leaving my computer resource. I do not have any control of the mail. So the time of dispatch will be the time that is recorded in my system as sent. The sent time will be the time of dispatch. Are you getting it? What I'm trying to say? I send you a mail at 11:59 a.m. and then it leaves my computer at 11:59 a.m. So the time of dispatch will be 11:59 a.m. Whatever time it may reach your destination, but from my place it goes away at 11:59, and beyond that I do not have any control of the same. So the time of dispatch is presumed to be the time when I actually send it, which is nothing but 11:59 a.m. When it is outside my control, when it leaves my particular system. Yeah, next slide. Okay. Second, when the addressee has given me a particular designated computer resource. So for example, I specify I have two email IDs. One is official, one is personal. So I say, should you have to send any official communication, please send it only to my official ID. So I designate and say this is the computer resource for the purpose of receiving this particular record. Then when does the time of receipt occur? Time of receipt occurs when it enters into my computer source. So suppose it is reaching my inbox at 12, then the time of receipt will be 12. This is when I specifically ask you to send it and you send it to the same one. Suppose you have sent it to something which I have not asked you to send. For example, like I told you, I asked you to send all official communications only to my official email ID. So if you send it to my official email ID, the moment it is received by me in my official email ID, the time of receiving will be the time of receipt. But suppose you do not send it to my official email ID, you send an official communication to me to my personal email ID. Then when does the time of receipt occur? Time of receipt occurs when I actually open that email ID. It may be 1 week, it may be 10 days, it may be 1 month. From the time I retrieve it, only that will be the time of receipt, not the original time of sending. Please understand this point. So I'm once again repeating it. Suppose I designate and say this is the computer resource that you have to send the electronic record. If I'm sending it to that particular designated computer resource, the moment it is reaching it, then that time is called time of receipt. Now, if I ask you to send it to a particular designated computer resource, you don't send it to me to that computer resource, designated computer resource. You send it to me to another computer resource. Then the time of receipt occurs when I actually retrieve it. It may be 10 days, it may be 1 week, it may be 1 month, but not the time when it is received by me technically. So this is again a clarification, technical clarification, legal clarification. So be aware of this particular point. So time of receipt, if it is a directly designated computer resources there, then the moment it is reaching my inbox, that is the time of receipt. Suppose you don't send it to my designated computer resource. Whenever I access that email, that time will be considered as a time of receipt, not the time which it was actually reaching my inbox. Are you clear? Are you able to understand the logic now? Participants, again, some response from you. Are you clear? Any doubts? Do you want me to again explain? So please let me know.
No, it's good.
Sure, are you clear? Okay. Now, if the addressee has not designated a computer resource with along with a specified time, the receipt occurs when it enters into the computer resource. Simple. When I don't give you any particular email ID, I ask you whether you can send it to my personal or professional. Any email IDs are fine. Then the moment it is reaching the inbox, that is the time of receipt. If I'm giving you, it is only this particular email ID, then the moment it is reaching that inbox, then it is the time of receipt. Suppose I tell you that this is the email ID I have to send, but you send it to another email ID of mine, which is my personal email ID. Whenever I access it, that will be the time of receipt. And likewise, when I have not specified the particular computer resource, you can send it either to personal or official, any of them. I leave the choice to you. So you send it to my personal email ID. The moment it is reaching my inbox, that is considered to be the time of receipt. Are you clear on this also? Any doubts?
No.
Yes, next slide. Okay, now let's talk about the place. Now the electronic record is deemed to be dispatched, place of dispatched, where the originator has his place of business and where the addressee has its place of business. This is the time of place of dispatch, place of receipt. I am located in Hyderabad. You are located in Bangalore. So I have my primary business in Hyderabad. You have your primary business in Bangalore. Now I am sending an electronic record by an email to you, and I'm my place of acknowledgement, my place of receipt will be Hyderabad. Your place of uh, acknowledgement will be Bangalore. So dispatch and receipt. Sorry, the place of dispatch will be Hyderabad. The place of receipt will be Bangalore. You're getting the point, right? So if I am located in one place, wherever my place is there, that place becomes the primary place for dispatch. If you are located in one place where your business is, then that place is presumed to be the place of receipt. Okay, now let me give you another example. No matter, I'm an originator, you're the addressee. Okay, fine. I am located in Hyderabad, you are located in Bangalore. Fine. I am using the server, a service of an email service provider. Let's say I'm using Gmail. Gmail has got the servers located in US, for example. US has got nothing to do in this transaction. Please don't get confused. Wherever is my intermediary located, I am not bothered. Place of dispatch is the place where I have my business, which is Hyderabad. Place of receipt is the place where you have your business, which is Bangalore. No matter the server may be located elsewhere, I'm not concerned about that. But the concern is place of dispatch, place of receipt. Are you clear about this? Because there are chances that I might quiz you in these directions as well. So I'm dropping some hints also so that you are aware of it. Because
Once,
wherever it is,
okay, so it
please,
will
please,
be,
you go ahead.
okay, sorry.
Go ahead,
So
go ahead.
place of dispatch and place of receive, that will be completely depend on where your business is located,
Correct,
irrespective of your location also, right?
correct, correct.
Okay.
So if my business is located in Hyderabad, the place of dispatch will be Hyderabad. If
Uh,
you being the addressee, your place of business is in Bangalore, place of receipt will be Bangalore. The
okay.
servers may be located in some other country. We are not bothered. But
Mm.
currently, all we are concerned is the place of dispatch is the place of the originator. Place of receipt is the place of the uh, addressee, the principal business place, not the residential place, the business place. I might be traveling abroad. I might be in the flight when I'm accessing it, but that doesn't care a damn for it. The place of dispatch, place of receipt only will be these places. Are you clear on it? I might quiz you in all the directions. So be prepared on this because confusion is presumed to be there, and I presume to create a lot of what do you say confusion. My intention is to confuse you so that I want to pull out the interpretation from your end. So that is where I'm trying to give you a disclaimer once again here because last time also I told the same thing to the last batch guys also. There is going to be a lot of confusion, but you should have great, no confusion, great combination should be how we should look at it. So the combination you should look at is place of dispatch is the place where my business is located, originator place, and place of receipt is the place where the originator, addressee has their principal place of business, not where I reside. Be very clear on that. Place of business. Okay, now let's go a bit more further. Now, there's another question that is going to be there.
One more question.
Please go ahead.
In that only.
Please
So
go
it
ahead.
might happen that principal place, also place of business might be in different cities also.
Excellent. We are just coming to that. We're
Oh,
just coming to the same point. Now,
okay.
see, now computer resources will be located in a different place from the place where the electronic record is deemed to be sent. But still, this will apply. Please go to the next slide, Pranav. Yeah. Now, if I have multiple areas of business, let's say I have offices in Bangalore, Chennai, Kerala, Bombay, Delhi, and all that. But my principal area, where is my headquarters? My principal place of business. That will be the place of dispatch or place of receipt in case I have multiple places. And likewise, if I do not even have a place of business, then residential address will come into picture. So this is the point that you have to be aware of. So if I have multiple places, wherever is my primary or the principal place of business, that will be headquarters. To put it very simple, uh, wherever is my headquarters located, that will be the place of dispatch or place of receipt. And if I do not have a place of business, I just have a place of residence, then the usual place of residence. Definitely, I'll be located in some other place. No, either I'll have an office or I will have a residence. Can't be that a person cannot have a residence. Definitely, he will have a residence. If I have my business at no problem. If I do not have my business place, then the place of business will be the residential place. That's the presumption that the law will give you. So are we clear on here? Any doubts, any clarifications? Number one, let's go back to the time now. Let's go back to the time now. First section that we discussed. Time of dispatch occurs when it is sent from my side and of which I do not have any control of. So that is the time of dispatch when there is no specific designated computer resource. So time of dispatch, I'm aware. Now time of receipt. Now the moment I say it is reaching to my inbox, that is the time of receipt. If I don't mention anything, suppose I mention and say this is the designated computer resource to which you have to send, and you send it to the same designated computer resource. Then the moment it is reaching my inbox, I'm taking email as an example. It may be anything. The moment it is reaching the
Computer resource.
addressee computer resource, that is supposed to be the time of receipts. But if I specify and tell you that this is the designated computer resource that you have to share it, but you do not send it to that, you send it to a different one. Then the time of receipt occurs only when I open it, only once I retrieve it, not when it is reaching my inbox or once it's reaching my computer resource. Only once I retrieve that, that is considered to be the time of receipt, not other way around. So, and when I do not mention it, suppose, then there is no issue at all. I'm clear on this. Are you clear on these two aspects? Time and
Yes.
the time of receipt. Now let us go to the place of receipt, place of dispatch. Place of dispatch is when I'm wherever I'm my business is, that is supposed to be the place of dispatch as an originator, and wherever the addressee has their primary their place of business, that is the place of receipt. Place of dispatch is the originator's place. Place of receipt is the place of the addressee. That's clear again. Now let's go a bit more further. When I have multiple areas of business, primary or principal or headquarters will be the one that I have to look into. Either for the matter of I mean, what do you say? Either for the matter of uh, place or whatever be it. See, if I have multiple places wherever I'm located, place of dispatch or the place of receipt, whatever it be it. If I have multiple places, my principal place. Either for the originator principal place, either for the addressee the principal place. So no matter wherever you are located physically, that's going to be the principal place. In case multiple locations are there, only headquarters or principal place. Suppose I don't even have that, then my usual residence is supposed to be my place of business. Then the place of dispatch will be the residential address of the addressee of the originator. Place of receipt will be the residential address of the addressee. Clear?
Yeah. Clear.
Sure. So
Sure.
we discussed three things: attribution, acknowledgement, and time and place. So
Yes.
attribution, I can attribute an originator in three cases. If I'm directly sending it myself, then the attribution is to the originator himself. Second, if the originator is authorizing somebody to do it on his behalf or her behalf, then the source is again attributed to the originator, not to the person sending it. Third, if there's an automated system used for sending the response, then the attribution is done by the addressee, I mean, to the
Original.
originator, not to the respective automated system. So in these three cases, I'm attributing the whole thing to the originator, not to anybody else. No system, no individual, and in the first case, of course, no need because it's directly being sent. We're clear on these three aspects, right? Attribution is clear now.
Yes.
Now acknowledgement. Now when I say that but that a particular electronic record is has to be acknowledged, then I don't specify whether it has to be acknowledged or not. I don't stipulate and say that it is binding on acknowledgement also. I don't speak anything on the acknowledgement. Then how do you send? How do you actually try to understand the acknowledgement? Acknowledgement can be understood in two ways. One thing, when there is any act or conduct or communication made by the addressee or any conduct, communication conduct on the part of addressee, then it is itself an acknowledgement. Then I don't stipulate anything that acknowledgement has is there and it is binding only on acknowledgement. Suppose I say that the respective electronic record is binding only in case you acknowledge, and in case I don't acknowledge, it is presumed that it has now been sent. So very simple. No acknowledgement, two ways. Suppose acknowledgement has to be there, then if I don't send it, it is presumed it is never sent. Okay. Now the third case. Now I don't tell you that it is binding on acknowledgement, but I don't receive the acknowledgement neither from your side. Then how do I do it? I have to mail you and intimate the addressee once again saying no acknowledgement has been received. If a time is specified there within the time frame or within a reasonable time, you can determine whatever is the reasonable time. Usually 10 days, 15 days, 1 week, 1 month can be considered a reasonable time. You have to intimate them asking them to acknowledge But in the first case, you might or might not have mentioned the time. But in the second intimation, you have to definitely tell them about the time period. So you'll have to tell them that you have to acknowledge the same within such and such a time period. Now, if they acknowledge it within that time, well and good. Otherwise, it is presumed that it has now been sent. So that is the third case. So this is with respect to acknowledgement. Now, place, we already discussed time and place. So I'm not getting into that. So I hope this gave you a clarity with respect to these three provisions. Are we clear on this?
Yes.
Attribution, acknowledgement, time, and dispatch.
Yes.
Great, excellent. So I'm really happy that we were able to discuss a lot of things today. And once again, I would just want to give you a total synopsis of whatever we discussed in the post lunch session. Then I'll go back to the morning session as well. Post lunch, we discussed about what is a computer. We discussed about the concept of a communication device. Then we discussed about what's an electronic record, electronic contract. Then we discussed about digital and electronic signatures. We discussed about e-contract. Then we discussed about the different provisions of the IT Act 2000 and 2008. I discussed with you about the authorities under the IT Act. We discussed about the certifying authority, controller of certifying authority, certain. We discussed about the computer emergency response team, which is the nodal agency for maintaining cybersecurity, and I also ran you through the kind of adjudicating officer and their mechanism, how they operate, jurisdiction, pecuniary subject matter, territorial, then up to 5 crore rupees, the adjudicating officer will have the power to adjudicate matters. Civil court powers has been given to him. Beyond 5 crores, you have to go to a civil court. For a criminal court, you can directly, a criminal matter, you can directly go to a criminal court. You can then go to the high court. Then you can go to the Supreme Court. And for civil matters, up to 5 crores, you have to go to the adjudicating officer. Beyond 5 crores, you can directly go to a civil court. But in case you want to appeal against the order of the adjudicating officer, you have to now go to TD-SAT, which is an appellate tribunal, cyber appellate tribunal, because cyber appellate tribunal is now merged with TD-SAT. So therefore, you have to go there. And if you are still wanting to appeal further, you can go and appeal in the High Court. Then you have to go to the Supreme Court. So these are the different stages. I also gave you an understanding on that. We discussed about the IT Act being a special statute and how it has overriding effect over other laws. And we also discussed about the various new kinds of crimes that have been added to the latest 2008. We discussed about what are the pitfalls in 2002, how they were rectified in 2008, and what could be the probable issues that we look at. I also one more time highlighted that hacking under Section 66 is no longer there. It was there in IT Act 2000, but subsequently when the law got amended in 2008, the term hacking was removed. We don't have hacking at all. And 66A is struck down as illegal by the Supreme Court because we do not have, it breaches the fundamental right of freedom of speech and expression. So no 66A can be used in any case by the police or by the lawyers to file the cases. So this is the broad overview. I told you what is not accepted in the electronic format, like trust deeds, wills, power of attorney, sale documents relating to immovable property, or conveyance documents, then negotiable instruments other than check. These are all not accepted in the electronic format. The reason also I told you because of stamps and registration and things like that. Then we'd also discussed about the different kinds of provisions like protected system. The government can declare a computer network, or a computer resource as a protected system. Once it is declared as a protected system, even if somebody accesses it accidentally, unintentionally, no damage is caused, but still 10 years could be the imprisonment that that person can be facing. But no provision has been used so far by the government. Then I also discussed with you that cyber cafes have been defined. We discussed about cyber security's definition, that cybersecurity does not mean only the information security, but also the physical security of the device is covered. Computer, we discussed three elements for a computer, which which are computing power, arithmetic and logical unit, memory, and communication device. Any device which is capable of storing, transmitting, receiving audio, video, image, and text. That is called a computer. Electronic signature, digital signatures also we discussed. Digital signatures are some things that you can purchase from the certifying authorities, which come in the form of a USB token. And electronic signature means biometric, retina scanning, Aadhaar-based OTP related signatures. All these are electronic signatures. Both these are how you different, and they can both be used for the purpose of authenticating an electronic record. We discussed about what's an electronic record. Any record, any information which is created using an electronic equipment, that's called an electronic record. So this is in fact the broad perspective. I also discussed with you about what civil matters are and what criminal matters are. Civil matters always talk about damages by way of compensation, that is money, monetary damages, monetary claims, and the criminal are always sending someone to jail, imprisonment, penalties, and fines, basically. Then we also discussed about what are cyber contraventions and cyber offenses. Both are violations, but one is a simple violation, other is a serious violation. One which is simple is always compensated because it is civil in nature. The one which is serious, excuse me, the one that is serious, that is offense, and then imprisonment, sending someone to jail, it's always criminal in nature. So we discussed both these things also. And I also discussed with you that cyber cafes have been defined. We discussed about intermediaries. Who are intermediaries also under, when you provide a service with, electronically, when you collect information, when you collect any electronic record, you provide a service with respect to that record, you become an intermediary. So anybody can be an intermediary, no matter whether it's an individual or no matter whether it's a company. Both can be called an intermediaries. So that's the whole gamut of our discussion today to give you a concise view on the afternoon session that we discussed. And in the morning, we discussed about the relevance of IT Act, how IT Act was introduced, why was it introduced? Because India was party to INCITRAL convention, and it had to be introducing its own national cyber law based on the principles of INCITRAL model law of commerce. That is why the IT Act had come into picture. It is an act which is providing legal recognition to electronic transactions. It's a law to promote e-commerce, boost e-governance, and also give legal recognition to any kinds of electronic contracts. So this is the whole fundamental objective, and it's not a penal statute. And apart from that, certain crimes, certain contraventions have been defined, punishments and penalties have been initiated. But it's not essentially an exclusive penal statute like the IPC. IPC, the word itself says Indian Penal Code. That means it's a punishment law. But this is not a punishment law. And we also discussed about evidence, what that the IT Act has made amendments to the evidence law so as to include digital evidence also, banking, digital transactions that we are doing today, the e-payment systems that we are doing, then the aspect of IPC to include the offenses. For example, I gave you the example of forgery. E-forgery can be initiated, e-cheating can be done, then online defamation also is included under IPC. So all these are some provisions which got introduced because of IT Act. It's a facilitating law. It has facilitated certain changes even in the existing and traditional law. So IT Act is a combination of all laws with an E added to it in simple sense. And we discussed about different aspects, how different verticals can be impacted by cyber law, that is the IT Act. So this was the whole discussion. We spoke on metaverse, artificial intelligence, blockchain, cryptocurrency, smart contracts, then some COVID related activities, fake news, then how the new cyber sovereignty is introduced, 3D printing. Then we also discussed about how interception and monitoring is done by the states, and how are they trying to exercise more power over citizens post-COVID era, or the let's say that during the COVID and post-COVID era, how we had some issues. We discussed also some aspects relating to e-contracts, click, shrink, browse wrap contracts. We also discussed about how the e-contracts are now being used by companies. Then all these were some things. Then we discussed about the consent mechanism, that there has to be free consent. Simply having I agree button and then a checkbox will not be a proper informed consent. So I accept, I decline, both need to be given. So all these were different things that we discussed. To sum it up, I think the whole crux of the sessions today were these. So I just gave you a concise overview. So on all of the discussions that we had, since morning till now. So I think this is all that I have got to say for today, and I'm open to questions. If you have any questions, then we can have some discussions and deliberations. And once we complete that, I think we can wrap up the session and wind it up today. So participants, thank you once again for bearing with me. It's been lovely talking to you since morning, and I hope that we have good interactive sessions for the other sessions as well. So I'm really fancied because unlike the normal participants, you've been quite interactive with me, and then a lot of different questions have been coming up from participants. I'm really happy and excited to again interact with you. So I'm open to questions if you have any.
Yes, I have one very important question.
Please go ahead.
What to refer for tomorrow's MCQ?
Nothing. Whatever we're discussing right now, and then we
Okay.
also will be discussing whatever we will be discussing the other day. I mean, the next day when we discuss, cyber crimes, we're going to discuss about the different kinds of cyber crimes, the different sections relating to cyber crimes and cyber contraventions. Then I'd also be giving you some kind of an understanding on some case studies, and then your MCQs will be based on those discussions and these discussions both. So I would urge you to clarify your queries before the MCQ, because I think we would like to schedule the MCQs post the session tomorrow,
Okay.
so that you have an understanding on the same. So anybody else? Any other queries? Any other discussions that you would like to have? Participants, what was your first experience on something on cyber law? I want to just hear your feedback. How did you find the subject, and how do you, I mean, what?
Yeah, it is interesting actually.
Mhm.
Exciting also. You know so many things.
Because we were just considering the criminal part,
Yeah.
but other aspects are also there.
I think that is where we are all drawing our attention to. There is, I mean, that's what people say, no? If even in the movies and the series that we are watching today, I think the criminal element is something fancies people, not something which is going cool and calm.
Mm.
Yeah, actually true.
Great. Then come on, other participants, I would like to hear your feedback as well. So, how did you find the dwell into the cyber law landscape?
Yeah, it was good, Sushanth. Interesting.
Thank you. And I'm happy. I'm glad that you're showing interest, because this is one subject which lawyers tend to take a step backward. Reason being, it's too technical, and technical people tend to go 2 steps further backward, saying this is something legal. So ultimately, like I told in the beginning, speakers come with some knowledge, the participants come with some knowledge, and ultimately it's the knowledge that is getting deposited in the university. So I feel that has not happened in this domain. Unfortunately, it didn't even get deposited in the university. Otherwise, you would have had a lot of universities offering this as a program. But unfortunately, I don't see this included at the bachelor's level in 99.9% of the universities, even the top-notch universities. They
We
just
can
have
start
one
with
or
Reva.
Reva is
See,
already
Reva.
doing a very good job. So in fact, I was just telling Dr. Shino about it, that glad that they've made efforts to introduce this as part of their program, because very few people understand the nuances and the importance of this. That is where the problem is.
And going outside and getting this knowledge is also difficult. Like other
Yeah,
governance and then you can easily find courses and everything. But getting knowledge about cyber law, it's quite difficult outside. Like
correct. And the other reason being that not updated. See, that is where the problem is. The sickness is that see, I'm the third generation lawyer in my family, and when I was studying my LLB, I was literally taken by surprise, because when I was discussing it with my father, then he told me the same subject, same books also, and some questions are also same what they had in their exam and now. So unfortunately, we were doing the same old traditional stuff. But when I started my career, I did a parallel career along with my LLB when I was passionate on this area. So I really understand. It's a difficult agenda to get outside and then start working on this domain.
But it's quite interesting subject.
It's a very, very fascinating subject. In fact, I was moved by it when I heard it for the first time. And I'm very thankful that at that point, we had a program also conducted in association with CRAT. CRAT was doing its first program, Cyber Regulatory Appellate Tribunal, and I was fortunate enough to be part of that program where we had Justice Rajesh Tandon, who happens to be the first chairperson of Cyber Regulatory Appellate Tribunal. And I still remember that we had got our certifications of that one-day program from him, and it was really at that point I knew that this is a place where I can constantly look at specializing in. It was literally fancied. I mean, I can almost tell you 2007 is when I first began to do my first program in cyber law. When I just started my LLB at that point. And it was my privilege that at that point, we had Asian School of Cyber Law, which did a lot of pioneering work in terms of cyber law education. They rolled out different programs, and to my benefit, everything was online, and then distance mode of contact classes were there. I went on to attend the contact classes as well, but that really paved way because by the time I finished my 5 years LLB, I already had say 18 to 19 certifications by then already, and it was a very, very interesting domain that I was looking at. And I was also luckily into cybercrime investigation, cyber forensics, and I got the real privilege to work on some cases because all their examinations were practical. They had the first private forensic laboratory in India, cyber forensic lab. So we used to go to the forensic lab, and then probably our exams also they used to give us the practical material, and then we were required to solve those, and then those the questions were containing pieces of information from those places. So we had to study, we had to do investigation, we had to literally pick up the right relevant piece of evidence. So thereby everything was something that we got practical exposure to, which I feel was the need of the hour. I don't know whether these programs are not still there with them, but I was really fortunate at that point to get this hands-on from them. Basically, that really helped me to get an understanding. Though I have not practically got into that domain for consulting. That's only limited to an advisory part because I can't sail on two boats. Bar Council doesn't allow me to do that. So but I have, but it really has given me a good insight and an understanding because I was able to challenge some forensic reports in some cases. So that really helped me to practically understand, practically the footing of how this can be done practically. So that's something that I could do, and I was also fortunate that at that point, now the UGC has come up with this statement. I don't know whether you are aware, saying that two bachelors, two master degrees can be done simultaneously. But unofficially, I think I have done my bachelors and masters together because once I was in my fourth year, I got admission into this masters MS in cyber law and cyber security from National Law University Jodhpur, and it was then that program was only open to enforcement agencies and not open to public. So I was just under the hope that by the time at least I had 12 15 certifications already, and I'd done two internships, and I was really expecting whether I can get into that domain. As a special case, the dean had granted admission to me for joining into the program, and because of which, though the program was boring because the law subjects were very boringly explained, 9 to 5, the same classes what we have today was also there at that point. But we thoroughly enjoyed the cyber security aspects because we practically got to understand a lot of different insight about the forensics and security. I was also into that domain already, but more in-depth understanding was given because our mentors were people who were top-notch in the industry at that point. So it was really fascinating for me, and I rolled out in 2012, and then the same month I started my practice. Now it's 10th year that I'm celebrating, but I must say it's a very fascinating journey that I had, and thanks to Reva also for this opportunity. So So any other feedback from any other participants? I would just love to hear it, and then we can wind it up.
I think we are good.
Okay, participants, it's I think we will catch up on a very interesting note of cyber crimes and the legal interpretations in the next session scheduled on 30th. So till then, have and be safe from COVID as well as from cyber offenses. So hoping to again uh, have an exciting, insightful as well as good interactive session on 30th. Thank you so much. I think
Sure.
we can wind up the session for today.
Thank you.
Thank
Thank you so much.
Shubham.
Thank
thank
you.
you.
Thank you.